let's see what's going on. Okay, Ms. Greenhouse, good morning. And
Good morning, Judge.
morning. Okay. Good morning, Mr. Rocco. Courtroom 2 is here. ACDC. All right. Let's see, Mr. Haddad. Good morning, ladies and gentlemen. My name is Judge Law, and I just want to make sure. Mr. Scirocco, can you hear me all right?
I can, Your Honor.
Okay, great. As I was saying, my name is Judge Lal, and this is going to be the state all-purpose misdemeanor calendar for today, which is going to be May 7th, 2026. The individual who's wearing an orange t-shirt, could you please switch your video off? We're not interested in watching your grooming. Thank you. Please switch your video off. Or the host can help him. Thank you. This is the state all-purpose misdemeanor calendar. These are misdemeanor cases in which individuals who were recently arrested and charged with certain offenses. Your cases have already had their first appearance, and today we're going to determine how you would like to proceed with your particular case. Most of the defendants have had an opportunity to speak with their attorneys, and based on the recommendations provided by the prosecutor, the defendant may either accept a plea offer and will have a plea hearing with regards to your case today, or you may decide to plead not guilty, in which case your particular case will be further noticed for trial. Whichever is your decision, please remember that when we are addressing each of your cases, you have a right to remain silent. Anything that you choose to say during the course of this virtual proceeding, your statements can and will be used against you in the treatment of your case. This whole proceeding is being recorded, so please be mindful that if you have any comments to make, wait till your attorney is available to speak with you. You have a right to an attorney. If you cannot afford one, one will be appointed to represent you. I know we have a couple of cases with private attorneys and conflict counsel. I don't see anyone on the Zoom right now, other than our public defense attorneys. So let's begin with ACDC. Good morning, Deputy Milton.
Morning, Your Honor. Position 8, Miss. Come on. What's your name? Miss Clark. And then after that, position 18 and 19.
That was position 9 on my calendar.
Oh, yeah.
No, that's fine. This is Chantel Ebony Clark, case number 26 CR 002754K. This case is, I believe there's a co-defendant, Julian Crumbley. But in this particular case, Ms. Clark, you've been advised of your rights, and your attorney is Mr. Haddad. I understand this is going to be a bond hearing. Mr. Haddad, has she waived arraignment or?
Not yet, Judge.
All right.
Started at felony, just so the court's aware. Both her and the co-defendant were felony cases, Judge.
I'm aware of that. Yes, 26 PI 2906. Yes, I know. So, so right now, Miss Miss Clark is got a $9,000 surety bond. I believe that was the bond set by the magistrate judge when the warrants were issued. So, what are we addressing today?
Judge, in light of the fact that it's got pushed back to misdemeanor, Judge, we're requesting a $4,000 bond, Judge, if I may be heard on that issue.
You may. Before we proceed, okay. Before we proceed, Miss Hutchison, may I have GCIC on Miss Clark?
Yes, she has 5 cycles, a 2026 January of this year conviction for simple assault and willful obstruction that appears to be a first offender. So she is actively a first offender. Also, was an aggravated assault with that case. A disorderly conduct conviction from 2025, and then a DeKalb arrest for aggravated assault from 2024 that appears to be open because there's no disposition. And nothing further.
And that was aggravated assault.
Yes.
Okay, thank you so much. 20. Okay.
be baby. I mean, niece.
All right, Mr. Haddad?
Your Honor, on behalf of Ms.
I'm sorry,
Clark,
I'm sorry.
she is 25 years of age, Judge. She has 5 kids, the youngest being 1, currently being taken care of by her mom, Judge. She's completed high school. She's also done a medical assistance degree, Judge. She was working up until her last pregnancy. Judge, she's from the Atlanta area. I would ask the court to consider a $4,000 surety bonds, anything to a little bit lower so the family can post bond. There are issues in the case, Judge.
Mr. Haddad, I'm going to stop you for a moment. I'm so sorry. I didn't mean. Okay, please proceed. I was hearing a lot of audio feedback, but I don't know where it's coming from.
Can you hear me
Are
better?
there, are there people speaking in courtroom too?
There is somebody on the phone, yes, Judge.
Oh, okay, I see. All right, go ahead. Sorry about that. Go ahead. So you said there were a lot of things about this case. What is it?
I mean, mostly because I think there's a co-defendant involved, and I think the evidence is going to show that it was the co-defendant that was more involved in the actual allegations that the state has painted. This incident happened at a Family Dollar, Judge, and I don't want to go into too
No,
many.
you don't have to. I've read the warrants in both cases.
So ultimately, Judge, what I'm asking for is a lower bond in light of the fact that it was started out as a felony, but the DA's office did not deem it to be a felony. I would ask the court to consider reducing her bond as such, since it's being treated as a misdemeanor. I'm not asking for a signature bond, Judge. I understand the history. I'm asking for a surety of $4,000, Judge.
All right. Mr. Scirocco, any comment?
Yes, Your Honor. First, we would ask that bond remain as set. We do think it's 9,000 total surety. We do believe that's appropriate. This did involve terroristic threats and acts involving to shoot everyone in the store, as you're aware. And there was, several actions with respect to party to a crime as to whether both of these individuals, their involvement in this case. I would contend that it would be considered party to a crime either way. But there's a lot that went on here. This defendant did so while she was on it appears probation for the aggravated assault 2026. And First Offender Act for the simple assault and obstruction 2026, as well as there's that disorderly conduct conviction from DeKalb, as you heard, a 2024 presumably open aggravated assault case out of DeKalb as well. So we believe a $9,000 total surety, $1,000 for each charge is appropriate here. Silent alarm had to be pulled. There's a lot that went on here, none of it good. So we are asking that it remain set, Judge.
Anything else to add, Mr. Haddad?
No, Judge.
Okay. Yes, I would agree with the prosecution. The allegations set forth in the warrants with regards to Ms. Clark and Mr. Crumbley are both very concerning and disturbing. There seems to be allegations of self-entitlement and open violence in front of strangers and in an establishment that they do not own. Ms. Clark has been in custody, I believe, now for about over 20 days now on a $9,000 surety bond. What is also most concerning, 2024 aggravated assault charges, 2025 more charges involving violence, 2026 new charges. Ms. Clark seems to be bent on a pattern of violence. And but I will amend the bond. On the battery, that's going to be a $2,000 surety bond. Simple battery is going to be a $1,000 surety bond. And the theft by taking is a $1,000 surety bond. The criminal trespass is going to be a $500 surety bond. That's a total so far of 4,500 surety. The remaining charges, the 1, 2, 3 counts of willful obstruction, the criminal trespass damage, and the terroristic threats, each one is going to be a $2,000.
And I have to spend $120.
2, 4, 6, 8, 10. That's going to be an additional $10,000 signature bond through pretrial services level 3. She is to have no further contact with Julian Crumbley. She's to stay away from the Family Dollar store in question, and she needs to stay away from that entire strip mall. She's to have no contact with the employers and the employees of that particular establishment. She will attend and complete 12 anger awareness classes while she's with pretrial services. She's not to consume any illegal drugs. She's not to consume any alcoholic beverages, and she's not allowed to have any weapons and firearms. Level 3 means that once she posts her 4,500 surety bond, she then reports to pretrial once a week. And this will be for a 12-month monitoring.
Thank you, Judge. I'll prepare the order.
Yes, I understand.
Next question. Shall I arraign this case, or will you be filing a waiver of arraignment?
I'll file the waiver, Judge.
This will be a waiver of arraignment. Ms. Clark, if you get arrested again, if you fail to report to pretrial services as directed, or if you violate any of the other conditions of the bond, your new bond is going to be an additional $10,000 surety. So please be mindful of these conditions. Try to avoid getting arrested again, and make sure you stay away and have no contact as directed by the bond holder. Thank you.
Thank you, Judge. And is the litigation manager today Ms. Champion or is it Ms. Young?
It's Miss Young, I believe.
Perfect. Thank you, Judge.
So,
Position 18 and 19, Your Honor.
Okay, thank you.
all
This
right.
is Sky Joyner, case number 25 CR 2E. And then she's got a failure to appear, case number 26 FTA 792. Her failure to appear carries a $4,000 cash bond for failure to appear for trial, I believe on September 9th, 2025. Ms. Joyner, you've been advised of your rights. And was this Mr. Haddad, your client as well?
It is, Judge. And this is yes, we're requesting a bond hearing. And if I may be heard, this is kind of a little bit unusual than your typical judge, if I may.
You may.
So, Judge, my client she was proceeding pro se at the time when she was dealing with the solicitor's office, and she was offered the diversion program. She enrolled in the diversion. She says she paid the fee, she completed the class, she got the certificate and sent it over to the solicitor's office. And that was that. She said she did not receive notice why she missed court. The reason I'm requesting essentially a signature bond, Judge, is she can't access her email for proof. One of the conditions, the offer from the state was that we have to bring proof by today. I can't do it. I mean, she can't do that, Judge. So under these circumstances, I mean, we go from a diversion type offer to a lot more strenuous recommendation, Judge, which is why I'm asking for a signature bond. I know this is unusual, but under the circumstances, I think it's appropriate to give her an opportunity to show that she has completed. And of course, if she, let's say hypothetically she hasn't, then she'll have to come back to court to answer those charges, Judge. But that's what I would ask for. And I can just say from personal experience with diversion with the solicitor's office, having high turnover, I have to believe her. I do believe her that she has completed what she was supposed to do.
Mr. Scirocco, do you know if Ms. Joyner was a diversion candidate with your office?
She was, Judge, and I had that she was received in diversion, and that was April 8th, 2025. It appeared that I believe the diversion participation fee was paid, but that's all I see for this case. Now it's been over a year since that date, but I don't see anything with respect to the completion of the terms here.
All right, thank you. On the failure to appear, her bond is going to be amended to a $1,000 surety bond. Will she be able to post the 1,000?
Uh, I don't believe so, Judge, but I'll see what I can do.
I'm asking you, can she post the 1,000 surety bond?
No, Judge, she cannot.
All right, let's amend it to a $4,000 signature bond through pretrial services, level 3. She reports to pretrial once a week. And during that reporting time, once she's released, I want her to produce a certificate and present that to the prosecutor's office in person. She'll need to make sure that she finds out what's the status of her diversion program and whether it's completed or not. So if she doesn't have the certificate, she still needs to report to the diversion office to find out why what's her status with diversion. Otherwise, she'll need to make sure that she has a current address with the Fulton County State Court at all times, and that she reports to court when summoned. She's been in custody now, I guess, for about, 10, 11 days?
Yes, Judge.
Okay. All right. So, Ms. Joyner, if you don't take affirmative steps to find out what happened to your diversion case, or if you don't report to court when summoned, well, you know what happens. Thank you.
And Your Honor, for clarification, does she have a signature bond on the underlying case? I'm trying to look it up on
Let
our.
me check with,
Yeah, $3,000 total pretrial.
right. Did she, was the pretrial bond surrendered, Ms. Hutchison?
Give me one moment, Judge. I have to check in Odyssey.
All right. If Mr. Haddad, on the position 18, if her signature bond was surrendered, we can amend that to be consistent with position 19, which would be a $3,000 signature bond through pretrial services amended to level 3. So that means her total obligation will be 7,000.
Thank you, Judge.
All right, I'll just wait for Ms. Hutchison to update. All right, Deputy Milton, I think we are concluded with ACDC unless you're bringing more folks.
Oh, no, I don't want
I think that's it, Judge. I'm not aware of any other ACDC cases, Judge.
to. Yeah,
Thank you. We have Oconee County Jail. Is the deputy seated next to the defendant?
Yes, Your Honor.
Good morning, sir. And what's the defendant's name, please?
Alex Dinard.
Oh, Judge, I can speak to him on the phone, Judge. I was gonna enter a plea of not guilty on his behalf.
Okay, I understand that, well, let me find out. Mr. Scirocco, this is Alex Dinard, charged with battery, case 26 CR 2204G. The case is being considered for a possible felony transfer. Any updates?
So we actually are seeking clarification. It may have been accepted. We had sent requests along with a follow-up for multiple cases. And I know it seems, at least it's clear that Mr.
Dinard?
No, apologies, Judge. I believe it was Quinlan Thomas's theft by shoplifting cases. I believe those were accepted as recidivist offenses by the DAs, but I need to clarify. We're trying to make sure that they also accepted this because it was in the same email. He said send them, and we need to make sure that it's both cases. But we know certainly at least that it was Quinlan Thomas's cases.
Quinlan Thomas's, and how is that related to Mr. Dinard?
In the sense that when the state was following up with the DAs on the pending felony transfer request for Alex Dinard, it's clear that they accepted Mr. Thomas's cases, but I need to clarify with the DA's office whether
I
they
see.
accepted Dinard's.
Okay.
And it's battery family violence. The charge, I don't know why it keeps appearing as this in the calendar, but it's a family violence case, Judge.
All
And
right.
recidivist.
My only concern and the reason that we're pleading not guilty, Judge, is he's been in custody since April 3rd. It was on the SAP on 4/16, same announcement from the state, it was reset to the 23rd, and now it's reset until today, and we're still waiting. Which
Okay.
I want to just plead not guilty on that case, and of course, we can always transfer it, but there's no point of getting you back on SAP calendar, Judge.
All right, shall I still consider this as a waiver of arraignment?
Yes, Judge.
All right. Mr. Dinard, this is a misdemeanor charge against you under in Fulton County, case number 26 CR 002204G. The charge is battery family violence from April 3rd, 2026. I am not sure if the DA's office, the district attorney's office of the Superior Court of Fulton County has made a definitive decision to accept this particular case as a felony. So pending that decision, your attorney, Mr. Haddad, has entered a not guilty plea on the misdemeanor charge. Do you understand, sir?
Yes.
So this case is going to be further notice for a jury trial pending whatever decision the district attorney office make with regards to this offense.
Thank you, Judge.
Thank you. Thank you, Deputy. Mr. Dinard's case is going to be further notice for a jury trial.
Thank you, Your Honor. I'll get information on the bond.
Okay. Next case, please, in courtroom 2.
We go 51, Mr. Wells.
I have a plea.
And Your Honor, if I get an update on Dinard while we're in court, I'll let you know as well.
I appreciate it. Thank you.
Your Honor, just to let Mr. Sirocco know, they amended it, but it was already filed as a battery family violence. I don't know why they amended it to battery, but I did correct it in the system.
Perfect. Thank you so much.
You're
All
welcome.
right. We have David Tyrone Wells Jr. Mr. Haddad, did you still need to speak with him?
This is another gentleman next to me, Judge, position number 3940.
39, sorry. Okay.
940 Cleveland Roberson, Judge.
Okay.
After I'm done with this plea, with the court's permission, I'll catch up on the other folks, hopefully,
Okay.
so I can.
No, I was just checking my cheat sheet that you sent me. Okay. All right. So this is 39 and 40, and this is Cleveland Roberson. Is it Roberson or Roberison?
Yes. Robert.
Okay, that's an I in there. Okay. So, Mr. Roberison, your case number is 25 CR 6777H, in which you've been charged with certain acts bus rail station prohibited. And you've also got a bench warrant under 26 FTA 791. You've been advised of your rights, and this is going to be a plea. May I place you under oath? Raise your right hand, please. For purposes of the plea, will you swear and affirm the testimony you provide will be the truth to the best of your knowledge?
I do.
Thank you. Mr. Scoracco?
Yes, Your Honor. As for position 39, the certain acts bus rail station prohibited, state is recommending time served, and we would just ask that he be met by a social worker prior to leaving for housing. For position 40, the failure to appear, the state will null pros that upon acceptance of the plea to position 39. We would ask that defense stipulate a factual basis, venue, and ID.
Do you so stipulate, Mr. Haddad?
They might be frozen, Judge.
All right. Mhm. All right. Mr. White, would you be able to call the courtroom 2 and just, or Miss Young, and just let them know there is. All right. Well,
I can give them a call. It looks like there's.
well, they'll come back in now soon, pretty soon. There we are. All right, Mr. Haddad, I'm so sorry. Your Zoom just now just did a little zap, but you're back.
Back, Judge, we're having stability Wi-Fi issues here.
Oh, dear.
But just to be clear, Judge, we stipulate, ask the court to follow the state's recommendation. I'm gonna have him speak to social worker at the conclusion of the plea, and that's where we cut off, Judge. So,
All right. But so the question was, do you stipulate to factual basis, venue, and ID? And I believe you answered that in the affirmative. Would that be correct?
yes.
Okay. So, Mr. Robertson, can you hear me?
Yes, ma'am.
Have you consumed any medicine or alcohol recently?
I have.
Are you still able to understand what's going on with your case?
Do.
Sorry?
I do.
And are you satisfied with your attorney?
Yes, I am.
All of that.
If you decide to enter a guilty plea to this charge of allegedly committing certain prohibited acts at a bus, rail, or station, you would have to waive your constitutional right to a trial in front of a judge or a jury. You will not have the chance to face your accuser, challenge the evidence brought against you in a court of law, provide your own defenses and arguments, and the state won't have to carry its burden and prove the charge beyond a reasonable doubt. Are you prepared to give up these rights?
Yes.
How do you plead to committing certain prohibited acts at a bus, rail, or station?
Guilty.
Sorry?
Guilty.
Your sentence is going to be the time you have served at the Fulton County Jail. If you have no other cases holding you, you should be released within 24 hours. But before your release, hopefully a social worker will be able to interview you to explore your housing options. Thank you.
Thank you, Judge.
The bench warrant will be dismissed. Thank you.
Next, we got 1 and 2, Mr. Achelis.
This is Fredo Achelis, accused of simple assault family violence under accusation 25 CR 006007E. And he's got a second case for simple battery family violence from April 24th of 2026. And the charge is the case is 26 CR 002633E. I understand, Mr. White, you're representing him, and Mr. Achelis has been advised of his rights. Mr. Achelis, may I place you under oath for your plea? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge? Yes or no?
Do.
Repeat.
I do.
Thank you. All right, Mr. Scirocco, what's the plea offer for both cases?
Yes, Your Honor. As for position 1, the simple assault family violence, the offer is 12 months probation concurrent with 26 CR 002633E. That is position 2. ADET, social worker visit for housing, no further contact with Jessica Dockery. Stay away from 916 Wood Creek Drive in Roswell, as well as 30 hours community service on that charge. And for position 2, the simple battery family violence, 12 months to serve 90 days, credit for time served, balance probated. The family violence intervention program, no further contact with Jessica Dockery, stay away from 916 Wood Creek Drive in Roswell, and 30 hours community service for a total of 60 hours community service. FFIB, ADET, social worker visit, no further contact, and stay away. If we could sound for the victim in this case, Ms. Jessica Dockery, at this time, I believe that is all for the state. We would ask that defense stipulate a factual basis, venue, and ID.
Jessica Dockery, if you're on Zoom, this is the time to unmute and start your video if you want to chime in. All right, Mr. White, do you so stipulate?
We do stipulate, Judge. We would ask just that probation, we'll waive the first 2 months of probation fees and ask that his probation term, go non-reporting once he completes all of his requirements.
Okay.
We would certainly object to non-reporting family violence cases, 2 of them here, Judge. No.
I'm going to deny the request for non-reporting. These are 2 alleged violence cases, literally back to back in less than a year. involving the same victim in the same location. But I will waive the probation fees for the first 2 months. I'm not sure how much longer he has to stay at the jail. Do you, Mr. White or Mr. Scirocco?
Yes, Judge. I discussed it with him yesterday. We're
Okay,
aware.
all right. Mr. Achelis, have you consumed any medicine or alcohol recently?
Take Capra to get last
I
night.
don't need to know the medication, so please don't disclose it in a public forum. I just need to know whether you've consumed any of these items.
Yes,
Okay? And after consuming them, are you still able to understand what's going on in both your cases?
yes,
And are you satisfied with your attorney?
yes, but may I please speak in my defense?
Yeah,
Mr. White?
there is no actual defense at this point if you're entering a guilty plea. If you want to talk to me again before we enter the guilty plea, we can do that.
Can I do that?
All
Sure.
right. All right. Deputy, Mr. Achelis needs to speak to Mr. White, so we'll take the next case.
We'll go to number 3, Mr. Andrews.
That's McLeod, I think.
Is Miss Maureen McLeod on Zoom? Yes, she is. Yeah, there she is. Good morning, Miss McLeod. Okay.
Morning, Your Honor.
All right. We are addressing your client, Contavious Andrews. Are you ready to proceed?
Your Honor.
All right. And how are we proceeding today?
Your Honor, this morning we would like to see if we could get Mr. Andrews' bond modified to a signature bond.
All right. Let's go ahead then with that. Mr. Andrews is charged with simple battery from April 23rd of 2026 under case number 26 CR 2647D. Mr. Andrews, you've been advised of your rights and your attorney is Ms. McLeod. What's his current bond amount?
$1,500
So
total surety, Your Honor.
1,500 good bond, Your Honor.
All right. And yes, Ms. Hutchison, could you refresh my memory on his GCIC?
Yes, Judge, it's pulling up right now. It's loading. It is. All right, I show a total of 15 cycles,
Mm-hmm.
a parole violation from 2014, a driving while license suspended or revoked from 2010, a theft by taken from 2000.
Any FTAs or is he on active probation?
He
I
does
mean-
not appear to be on active probation. He did have an arrest from 2020 that included a possession of a Schedule I controlled substance, but that disposition isn't listed on the GCIC.
Okay.
I do not see any FTAs.
Thank you, Ms. Hutchison. Ms. McLeod?
Yes, Your Honor. My client, even though it's not a high bond, Your Honor, he's been in jail for the past 14 days since the arrest. And he tells me that he's in no position to pay the bond, Your Honor. And also, he has nobody to help him. My client was injured in this. It is disputed. I've actually had the opportunity to go through the discovery. I've watched the videos and so on. And my client maintains that he was actually the victim in this case. And based on what I've seen, there is some evidence to support this contention, Your Honor. And there is a plea offer which would have allowed him to get out of jail within the next 24 hours. But he is disinclined to take it because he maintains that he is innocent, Your Honor. So I would like to ask for signature bond so he can have the opportunity to properly defend against this case on the outside, based on what I've seen.
All right, thank you. Mr. Scirocco?
Yes, Your Honor. This was that incident from April 23rd, wherein it was the victim, Mr. Ronald Wiggins, had reported they'd called 911 and explained that the defendant had entered his backyard and started an encounter by slapping him. He was defending himself. He struck back with a beer can, and the defendant admitted to going to that location over a personal dispute involving a girlfriend. The video evidence showed the defendant holding a stick and charging at the victim, was supporting the victim's account of the aggressive behavior. Defendant he had a strong odor of alcohol and was behaving incoherently, according to the officer. And there was, yeah, the primary concern, I believe, at C involved any further escalation of this. Appeared to be some jealousy involved, from what I can tell. And the state's recommendation, I did see a battery family violence as well.
It is, that's one from
2024.
2024, but there's
Yeah,
no disposition. Yeah.
it was dismissed, but it was a recent arrest, so I just wanted to bring that up. We would ask that the bond remain as set. I don't believe there's been any change in circumstances here that we can cite to so the state would ask that the bond remain set at the $1,500 surety.
Anything else, Ms. McLeod?
Yes, Your Honor, my client was actually injured. I did watch the videos. It did not seem incoherent to me when I watched, and he was bleeding from the hand where the other guy attacked him, and he was taken to Grady and all that. And he does maintain, I have spoken to him, I've been to the jail to discuss the case with him, and I understand the position that he takes, that he was not the primary aggressor here, Your Honor. And I would like him to be in a position where he can actually take this case to trial so that all the facts can be properly aired and the witnesses can be brought in and he can actually maintain the presumption of innocence.
Does he live at
Until-
does he live next door to 791 Metropolitan Parkway?
He does not, Your Honor.
Okay, thank you. Bond is going to be set at 3,500. It's a signature bond through pretrial services, level 2. He will report to pretrial services twice a month. He's to have no further contact with Ronald Wiggins, and which means he stays 200 yards away from Mr. Wiggins. He's not to communicate with him in any form or manner, including in person, mail, email, third-party phones and computers, and even on social media. And he's to stay 200 yards away from 791 Metropolitan Parkway in Atlanta, Georgia. This will be for a 12-month monitoring period, so he reports to pretrial twice a month. If he violates the conditions, if he gets arrested again for anything else, this 3,500 signature bond will be reverted to a surety bond, which means his bond will be higher the next time. He's not to consume any illegal drugs, which includes marijuana. He's not to consume any alcoholic beverages, and he's not allowed to own or possess any firearms. Thank you.
Your Honor.
All right, next we got number 10, Mr. Crumbley.
Oh, I'm sorry, Ms. McLeod. Well, are you filing a waiver of arraignment?
I've already done that, Your Honor.
Oh, you've done that? Okay, thank you.
Yes.
And I'm sorry, Deputy, could you repeat that name again, please?
Number 10, Mr. Crumbley.
10, thank you. This is Julian Crumbley. He is, we just addressed the co-defendant, Chantel Clark. Mr. Crumbley's particular case is 26 CR 2747A. And he's represented by Ms. McLeod. Mr. Crumbley, you have been advised of your rights. And how are we proceeding, Ms. McLeod?
Yeah, I'm going for his bond to be lowered, Your Honor. We
All right.
talked at length this morning. I know he does have a hold in DeKalb County.
And an open pending felony case here.
But I believe he has a bond for that one, Your Honor.
All right.
That's my understanding.
He's got a $6,000 surety bond in this case.
That is correct, Your Honor.
All right. And what are we looking at? Let me ask Ms. Hutchison. Ms. Hutchison, a report on Mr. Crumbley, please. Position 10.
Yes, he has a total of 9 cycles, a 2016 willful obstruction, no-low plea, a 2017 conviction for theft by receiving stolen property, fleeing or attempting to elude, and willful obstruction of a law enforcement officer, a FTA from 2024, and You stated the open felony case and then the open, he has a hold and nothing further.
And the hold in, was it DeKalb?
Yes, that's correct.
Yeah, Your
Or
Honor.
failure to appear.
All right, failure to appear in DeKalb as well.
Yeah.
All right, yes, Ms. McLeod, why am I reducing this bond? Or should I reduce it?
Because Your Honor, my client tells me that he wants to fight this case, but he would like to be able to bond out so he can go to his hold in the cab county, take care of that hold, and then deal with this case. He does not want to accept the state's plea offer, which I have looked at and I don't think is necessarily reasonable either. So it's just not a good offer, Your Honor. So he wants to be able to bond out so he can go and address this matter in Fulton County, then come back and deal with this case while he's on the outside.
Okay, Mr. Scirocco?
And he knows that he's not going to get a signature bond, Your Honor, but he believes if the bond is lowered, whether to a low cash bond or a lower surety bond, then he would be able to make that bond. And that's what we're trying to accomplish, Your Honor.
All right, and Mr. Scirocco?
Yes, Your Honor. To supplement a little bit with his history, I did see not one FTA from 2024, but two that DeKalb hold is for an FTA.
Oh, yeah, we just
And,
heard the GCIC. I know all
yeah.
that. I'm just
All right.
wondering whether,
Uh,
other than the FTAs, any other vehement objections to a bond modification?
Yes, we would certainly object, Judge. Frankly, I don't really understand. I mean, I read it with respect to the transfer paperwork, but I don't really understand why this is, at the very least, not a felony willful obstruction with respect to the actual visible harm caused to the officer. This is the same set of facts that you heard earlier. I know you've reviewed the warrants here. The threats to shoot individuals. This is a public safety case. And just as we were with the other defendant, Ms. Chantel Clark, we are requesting that bond remains set as is. With the current $6,000 surety, we believe that's appropriate given the circumstances, and we would ask for it to remain as such.
Ms. McLeod, the bond modification request is denied, and Mr. Crumbley will definitely have an opportunity to challenge these charges, even from where he's currently detained. His next court date will be, he'll be further noticed for a jail jury. Thank you.
Your Honor, that was what we would ask for in the event that this was denied, which it has been, that he be placed on the earliest available jail jury calendar, Your Honor.
All right, will do. Thank you.
Thank you, Your Honor. And that concludes my business for this part of the calendar. I do have 2 cases on the 11 o'clock, so I will log back on for that.
Appreciate it. Thank you.
All right, let's go.
You're welcome.
And let's go. Position 4 and 5, Mr. Bonner.
Number 5.
Mr. Bonner's a waiver. We don't need him.
Okay.
Yeah. I'm sorry. Oh, yes. Mr. Bonner's attorney has already entered so Charlie Bonner, this is a waiver of arraignment? Okay, thank you.
All right, we got 6 and 7, Mr. Boozer.
This is Aquavius Boozer, okay. Mr. White, are we still proceeding with a plea on this matter?
As far as I know, Judge.
All right. Mr. Aquavius Boozer is case 25 CR 7485B, accused of theft by shoplifting and possession and use of drug-related objects. He's got a bench warrant from January 21st of this year, 26 FTA 788. And Mr. Boozer, you've been advised of your rights. May I place you under oath for the plea? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
I do.
Thank you. Mr. Scirocco?
Yes, Your Honor. And for position, so negotiated plea, correct?
Yes.
Yes.
For position 6, the theft by shoplifting charge and the possession and use of drug-related objects, which are counts 1 and 2 respectively. For count 1, the state's recommending 12 months, serve 132 days, credit for time served, balance probated, anti-theft course, $500 fine, stay away from the Publix that is located at 950 West Peachtree Street Northwest in Atlanta. And for the possession and use of drug-related objects, count 2, 12 months probation concurrent with ADET and no illegal drugs while on probation. As for position 7, the failure to appear, the state will null cross that upon acceptance of the plea to the theft by shoplifting and possession charges. The state would ask that defense stipulate a factual basis, venue, and ID for purposes of the plea.
Your Honor, we do stipulate for the purposes of the plea, just for clarification, can he have illegal drugs when he gets off probation? Sorry, just a joke. That's just a restatement of the law.
I'm
Anyway,
laughing. I'm laughing. Don't worry. But all right. Anything else, Mr. White?
Your Honor, we would ask to convert the $500 fine to 50 hours of community service and ask probation go to non-reporting once he completes those requirements.
Is that another joke?
No, that's
No, okay. Just want to be sure. Thank you. All right.
We do object to non-reporting. He does have, there's an open probation violation case, felony court 26 PV 0000961. He does have a conviction for theft by shoplifting. Conviction as recently as 2026, but others as well from 2023. And I believe he's on probation for that. Actually, the case is 24 SC 004044. 3 years probation, convicted November 2025. And there's other theft. There's another theft convictions, other possession cases and convictions. So the state's recommending this not go non-reporting.
Judge, I would point out that he has been in jail 61 days on this.
I noticed that. Yes.
Or I'm sorry, 63 days. So.
132. Okay. Mr. White, I'm going to deny the request for non-reporting. I will amend the $500 fine to a $250 fine plus 25 hours of community service. And I'm going to impose the requirement of random screens to for illegal drugs, which includes marijuana. Would your client like to accept the plea as amended, or would he like to go to trial?
Mr. Boozer, do you understand what just happened?
Yes or no, Mr. Boozer?
So the judge is requiring that you have random drug screens while you're on probation. Are you okay with that?
Yes, I am.
Okay. Judge, we can go forward.
Okay. Mr. Boozer, have you consumed any medicine or alcohol in the recently?
No, ma'am.
Have you understood what's going on in your case?
Yes, ma'am.
And are you satisfied with your attorney?
Yes, ma'am.
If you decide to enter a plea to the theft by shoplifting and the possession and use of drug-related objects, you would have to give up your right to a trial in front of a judge or a jury. You will not go back to court to face your accuser, challenge the evidence brought against you, have the assistance of counsel to present your own defenses and arguments, and the state won't have to prove the charges beyond a reasonable doubt. Are you prepared to give up these rights?
Yes.
I'm sorry?
Ma'am.
Respond. What are you prepared to give up these rights?
Yes, yes, ma'am.
How do you plead to theft by shoplifting and possession and use of drug-related objects from October 13th of 2024?
Guilty.
Your sentence for count 1 is going to be 12 months to serve 132 days, credit for time served 61 days. The remainder of the time you'll be on probation. You will report to probation on Monday before 3 p.m. and you will be actively reporting to probation every month. While you're on probation, you will undergo a anti-theft class, and you will have to enroll in that class within 60 days of being released. You will also be required to pay a $250 fine, which you will pay at a minimum rate of $50 per month. I will waive your probation fees for the first 2 months. And then you're also to stay away from the Publix grocery store at 950 West Peachtree Street in Northwest Atlanta. In addition to paying your fine of $250, you will also be required to complete 25 hours of voluntary community service at any nonprofit agency that's not a church and not a school. You will complete your community service at a minimum rate of 10 hours per month. With regards to count 2, it will be 12 months concurrent with count 1, and the addition of no consumption of any illegal drugs, including marijuana. You will be subject to random screens for illegal drug use, and if you fail a single drug screen, your probation will be revoked. Within 10 days of being released, you must go to any healthcare provider and undergo an alcohol and drug evaluation and submit to all treatment and counseling as required. So by your second probation visit, you must show proof that you have completed the evaluation, and the evaluator will know where to send the evaluation report. Thank you.
Thank you.
All right, that's one number 12, Mr. Hamilton.
Right. Oh, for Mr. Boozer, his bench warrant is dismissed for null prost. Mr. Hauser, okay. Was that? Give me the position number again. I have a Houston.
Hamilton.
Oh, Hamilton, excuse me. Okay.
Position 12, Judge.
Got it. Thank you. Detovius Hamilton is accused of PI charge. We're going to waive sounding on that charge. His attorney is Jacoby Hudson. Is Mr. Hudson on Zoom? Deputy, Mr. Hudson's not reported yet. We'll probably have... Ms. Young, have you heard from Mr. Hudson?
I have not, but I'll ask Ms. Champion to reach out to him.
All right. Deputy, we'll have to hold on Mr. Hamilton until his attorney appears.
All right, next we got number 13, Mr. Harrell.
It's going to be a negotiated plea, Judge.
All right. Joseph Nicholas Harrell is accused of theft by receiving stolen property, criminal trespass, and giving false information to an officer from April 22nd of this year, accusation 26 CR 2590G. Mr. Harrell, please raise your right hand for the plea. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
I do.
Please repeat. Your response? What's your response? Speak louder.
No, just to answer a question. You said you do. You said when she swore you in, you swear to tell the truth and the truth, nothing. And you said yes, you do.
Yes.
All right. Mr. Scirocco?
Yes, Your Honor. For this is position 13, Mr. Harold, the state's recommendation on count 1, the theft by receiving, is 12 months served 32 days, credit for time served, balance probated, anti-theft course, no further contact with William Trice. For count 2, the criminal trespass, 12 months probation concurrent with count 1, stay away from all Georgia Tech premises and property. And for count 3, the giving false information to law enforcement officers, 12 months probation concurrent with count 1, 30 hours community service. We did speak with Mr. Trice. He is okay with the offer. He received his scooter back. He informed us yesterday, I believe. And yeah, the state would object to any non-reporting here. There was there's several open cases that I'll go into if need be, and recent conviction for a theft offense from 2026.
Any of the open cases holding him at the jail today? Other than this one?
A great question, Judge.
No.
I do not believe they are, Judge, but I'm not 100% certain of that.
All right.
I can confirm, no, he's not being held on that other, no.
Okay. Mr. White, does your client accept these terms, and do you stipulate to the factual basis, venue, and ID?
We do stipulate to factual basis, Judge, for the purpose of the plea. We would ask that you waive the first 2 months of probation fees, convert the third, I'm sorry, never mind. And then ask that his probation go to non-reporting once he completes all of his requirements.
All right, and you stipulate to venue and ID as well, correct?
Of course, Judge. Have
Okay.
a stipulation if you'd like.
No, just want to be sure. Thank you. Mr. Harrell, have you consumed any medicine or alcohol recently? You need to speak up so I can hear you.
No,
And do you understand what's going on in your case today?
I had a brief discussion with the attorney before I sat here and agreed with to the terms.
Are you satisfied with your attorney?
Yes,
And has it been explained to you that if you decide to plead guilty to these 3 charges, you would have to give up your right to a trial before a judge or a jury? You will not get the opportunity to go back to court, to speak, to confront your accuser, to challenge the evidence that would be presented against you, to present your own arguments and defenses through an attorney, and the prosecutor won't have to prove the charges beyond a reasonable doubt. Are you prepared to give up these rights?
yes,
How do you plead to theft by receiving stolen property, criminal trespass at Georgia Tech, and giving false information to an officer?
Guilty.
Repeat.
Didn't hear you. Guilty.
On the theft by receiving, your sentence is going to be 12 months to serve 32 days, credit for time served. Once you're released, you are to report to the Fulton County Probation within 48 hours and before 3 p.m. Within 60 days of being released, you are to enroll in an anti-theft class and make sure you complete that and present the certificate of completion to your probation officer. At all times, you are to have no contact with William Thrice. For count 2, criminal trespass, your sentence is 12 months concurrent to count 1, and you are to stay away from all Georgia Tech property. For count 3, giving false information, your sentence is 12 months to serve concurrent with count 1, and you are to complete 30 hours of voluntary community service at a minimum rate of 5 hours per month. You're to do the community service at any nonprofit agency, and it cannot be a church and it cannot be a school. You will report to probation every month until the remainder of the 12 months are completed. I will waive your probation fees for the first 2 months. And that concludes your sentence. Thank you.
All right, that's number 14, Mr. Hilburn.
So, we may need to hold Mr. Hilburn. There were 2 add-on cases that I don't have offers for.
I thought it was a global offer for the other 2 cases. Oh, you haven't received them?
You have.
Let me double check. I got you. Okay. I didn't notice that yesterday.
That's fine. Do you need to speak with Mr. Hilburn?
I can actually explain to him that, Mr. Hilburn, you did have 2 other criminal trespass cases, but it is not going to affect what we talked about yesterday. So we'll go ahead and go forward. Those will also be convictions.
There is additional community service on those, as well as a social worker visit for housing and stayaways from the various properties.
Let's let Mr. White call the jail and talk to
yeah.
Mr. Hilburn.
It's
Okay?
beyond what you put on the
No,
paper.
I've sent everything all at once. You received everything.
Then
This
there
is
is
all
an extra because I've already explained to him everything that was on the paperwork that you initially sent.
Okay, well then they're just clarifying.
Okay. Let's then go through the plea hearing, and if there are any questions, I guess we will take a recess on this case. All right, this is Reginald Hilburn. And Mr. Hilburn, you have 3 cases presently on this calendar. The first one is 26 CR 2593F. Mr. Hilburn is accused of loitering and prowling. and giving false information to a law enforcement officer. And this is from April 22nd, 2026. Mr. Scirocco, I'll need some details on the other two cases. The
Yes,
second
Your Honor.
case is 25 CR 004-584F. And what are the charges and incident date?
For add-on 3 is the position, the criminal trespass there from August 8th, 2025. And the other one is criminal trespass from February 16th, 2026. The August 8th incident involved a response to a prowler call, Judge. This was it's a Buckhaven construction company, and it was at that site that the defendant was on the site tampering with items there. There's a video of him.
I just needed to know the charge and the incident date.
Oh,
That's
okay.
fine.
I thought you were asking for factual
No,
basis.
just that. Thank you.
All right.
All right. So these are the three cases, Mr. Hilburn. Then the state has made a global offer, and Mr. Scirocco is going to go through the terms of the offer for all three cases. And if you disagree or if you want to speak with your attorney, you let us know. Yes, Mr. White?
Judge, I'm sorry. I'm going to need to speak with him briefly.
All right. Deputy, we'll address Mr. Hilburn shortly after Mr. White has had a chance to speak with him. Positions 3 and 4 add-on. Okay. Next case.
Position number 15, Mr. Houston. Houston.
Mr. White is going to be calling the jail. Can we take another case with Mr. Haddad?
Okay, no problem. Go ahead. We could go to position number
48, 49.
48, 49, Mr. Thompson.
Thank you. And with regards to the defendant who's waiting on his attorney, Jacoby Hudson, Mr. Hudson is currently in DeKalb County Court, so he will try to log on as soon as he's available. 48 and 49. Okay. Mr. Haddad, is this your client, Tamarian Thompson?
It is, Judge, and it's going to be a negotiated plea.
Thank you. Tamarian Thompson's accused of battery, family violence, and simple battery, family violence from March 31st of 2025 under accusation 25 CR 1726J. He also has a bench warrant from July 29th, 2025, and that case is 26 FTA 795. Mr. Thompson, you've been advised of your rights, and your attorney is Mr. Haddad. May I place you under oath for the plea? Please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge? Repeat. Thank you. Mr. Scirocco?
Yes, Your Honor. And I have a need to speak to announcement. This is a negotiated plea?
Yes.
Okay. For position 48, it's the battery, family violence, and simple battery, family violence, counts 1 and 2 respectively. For count 1, the battery, family violence, the state's offers 12 months or 22 days, credit for time served, balance probated, recommending the ADT, 8-week anger management. In this case, no further violent contact with Tiffany Thompson, as well as 20 hours community service. And this goes without saying, but no firearms. And the simple battery, family violence would merge with count 1. As for position 49, the failure to appear, the state will null pros that upon acceptance of the plea to the battery, family violence in this case. We would ask that defense stipulate a factual basis, venue, and ID for purposes of the plea. And if we could sound from Ms. Tiffany Thompson.
Tiffany Thompson, if you're on Zoom and like to chime in, please start your video and unmute your Zoom panel. All right, she's not here. Mr. Haddad, do you so stipulate? Does your client accept the terms?
Sorry, Judge, yes, we stipulate and ask the court to consider waiving the first couple months probation fees just in light of the fact that he has to pay for the anger awareness, Judge, the anger classes.
Okay. Mr. Thompson, have you consumed any medicine or alcohol recently?
No, ma'am.
Have you understood what's going on in your cases?
Yes, ma'am.
And are you satisfied with your attorney?
Yes, ma'am.
If you decide to enter a plea, you would have to give up your right to a trial in front of a judge or a jury. You won't get the chance to face your accuser, challenge the evidence brought against you, present your own defenses and arguments, and the state won't have to prove the charges beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to one count of battery family violence?
Guilty.
Repeat.
Guilty.
Your sentence is going to be 12 months to serve 22 days, credit for time served. Once you're released, you report to probation within 48 hours on the first business day, and you report before 3 p.m. You will report to probation every month thereafter. Within 10 days of being released, you will undergo an alcohol and drug evaluation and submit to any and all treatment that's required. Because while you're on probation, you're not to consume any alcohol and you're not to consume any illegal drugs, including marijuana. You're to complete 8 anger management classes. Those are once a week, and you're to begin those classes within 30 days of being released. I will waive your probation fees for the first 2 months, so please make sure that you sign up for those classes as soon as possible. You're also required to complete 20 hours of voluntary community service at any nonprofit agency, but it cannot be a church and it cannot be a school. You are to complete your community service at a minimum rate of 5 hours per month. At all times, you're to have no violent contact with Tiffany Thompson, which means that you can contact her and communicate with her, but there cannot be any physical or verbal altercations involved. You're not allowed to own or possess any firearms. Thank you.
Thank you, Judge.
Count 2 will merge into count 1, and his bench warrant is null prost.
And this we got 41 through 44, Mr. Say?
41?
Through 44.
Your Honor, I have the opportunity to speak to my clients. It's going to be negotiated plea judge and anticipate an additional 13 days in custody before release, assuming the court accepts the negotiated plea judge.
Thank you. Mr. Myron Shay is positions 41, 42, 43, and 44. 44 is a bench warrant under case number 26 FTA 725. Incident date is March 17th, 2025. The other 3 cases begin with 24 CR 3592E, accused of theft by taking from June 9th of 2024. The second case is 24 CR 6128E, accused of theft by shoplifting and willful obstruction from August 29th, 2024. And the third case is theft by taking from April 20th, 2026, accusation 26 CR 2541E. Mr. Shay, you've been advised of your rights, and your attorney is Mr. Haddad. May I place you under oath? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes.
Thank you. Mr. Scirocco?
Yes, Your Honor. For positions 41 through 44, on position 41's theft by taking, state's recommendation is 12 months probation concurrent with the 26 CR 002541E case. That is position 43. Stay away from Captain D's restaurant that is located at 1095 Ralph David Abernathy Boulevard in Atlanta, as well as 40 hours community service. For position 42, the theft by shoplifting and obstruction, respectively. Count 1, 12 months probation concurrent with that, again, position 43 case. Stay away from the 76 gas station / AJ package store. That's at 548 Northside Drive in Atlanta. And for the willful obstruction, there, 12 months probation concurrent with count 1 and a $300 fine. Lastly, for the theft by taking, position 43, 12 months served, 60 days, credit for time served. Balance probated. No further contact with LeBaron Dickinson. $350 restitution to LeBaron Dickinson. Stay away from 668 Cameron Madison Alexander Boulevard in Atlanta. And upon acceptance of the pleas here today, the states will null pros that position 44, failure to appear. We did speak with the victim, Mr. Dickinson. He's in agreement with the offer and is looking forward to receiving restitution for his property. So I believe he does want to speak here today. If he is online, we would ask the court sound for him. And we'd ask the defense stipulate the factual basis, venue, and ID.
LeBaron Dickinson, if you're on Zoom, please unmute and start your video if you want to chime in. All right, are you LeBaron Dickinson?
Yes, ma'am.
All right, please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Is the $350 the restitution that you information that you provided to the prosecutor?
Yes, sir. Yes, ma'am.
Anything else that you'd like to add?
No, ma'am.
All right, please mute your screen. Thank you. Mr. Haddad, does your client accept these terms and do you so stipulate?
Yes, Judge, we stipulate, accept the terms. Judge, as to position number, sorry, Judge. The one involving the additional custody time, which is position number 43, Judge. The records reflect that Mr. Shay has been in custody for 17 days as of today, Judge. So,
repeat that number, please.
1-7, Judge, 17 days.
Okay.
Based on my calculations, he does have an additional 13 days to complete. Upon release, Judge, I explained to him they'll have to report to probation. I would ask to consider the court maybe waiving the first month or first 2 months of probation fees, Judge.
All right. Mr. Scirocco, do you agree with those numbers indicated by Mr. Haddad?
I can't confirm really, but this was not intended to be a time served plea. So I believe he is likely correct.
Okay. I will waive probation fees for the first 2 months as long as Mr. Shay complies with the payment requirements for his fine and for restitution, as I will indicate. But if he doesn't make those payments for the restitution and the fines, as I'll indicate, then he'll need to pay those 2 months of probation fees that I'm initially waiving. All right.
Thank you, Judge.
So, and you so stipulate, correct, Mr. Haddad?
We do.
Okay. Mr. Shay, have you consumed any medicine or alcohol recently?
Can be taking alcohol right now.
No, ma'am.
All right. This is your moment, Mr. Shay, to speak up, because if I don't hear you, I can't accept the plea. All right? Yes or no?
No.
As in he understands, Judge.
Understood. Mr. Shay, have you understood what's going on in all 4 cases involving you today?
Yes, ma'am.
And are you satisfied with your legal services?
Yes, ma'am.
If you decide to plead guilty to 3 of these cases, you would have to give up your right to a trial before a judge or a jury. You will not be able to go into a court of law to face your accusers, to be able to challenge the charges brought against you and the evidence presented, and you won't have the opportunity to present your own legal arguments and defenses through an attorney. The prosecution will not have to carry its burden to prove all these charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to theft by taking from June 9th of 2024 at a Captain D's restaurant?
Guilty.
Your sentence is 12 months, and you are to stay away from the Captain D's restaurant at 1095 Ralph David Abernathy Boulevard, and you're to complete 40 hours of voluntary community service, and you are to complete that community service at a minimum rate of 10 hours per month. This sentence will be concurrent with position number 43. With regards to position 42, how do you plead to theft by shoplifting and willful obstruction of a law enforcement officer from August 29th, 2024?
Guilty.
For count one, the sentence is going to be 12 months concurrent with position 43. And you are to stay away from the gas station or the AJ package store located at 548 Northside Drive in Atlanta, Georgia. With regards to the obstruction charge, it will be 12 months concurrent with count one, and you are to pay a $300 fine, and you will pay that fine at a minimum rate of $50 per month. Now, with regards to position 43, how do you plead to theft by taking from April 20th, 2026?
Guilty.
Your sentence is going to be 12 months to serve 60 days, credit for time served 17 days. The remainder of time you'll be on probation. You will report to probation on the first business day within 48 hours of being released. While you're on probation, you will report to probation every month. I will waive your 2 months of probation fees initially, as long as you comply with the payment terms for the obstruction fine and for restitution. You will be sentenced to a restitution of $350 payable to LeBaron Dickinson. The restitution payments you make directly to your probation officer, and the probation officer will then direct the payments to the victim. You will make those restitution payments at a minimum rate of $50 per month. So your obligation per month is $100, $50 towards the fine and $50 towards restitution until the entire fine and restitution are paid off. At all times, you are to have no contact with LeBaron Dickinson. You're to stay 200 yards away from him and not communicate with him in any way, form, or manner. You're also to stay away from 668 Cameron Madison Alexander Boulevard in Atlanta, Georgia. Thank you.
Thank you, Judge.
Oh, his bench warrant is null prost. Thank you.
All right, going back to position 14, Mr. Hilburn.
All right, this is going to be a non-negotiated plea.
All right. Mr. Hilburn has been addressed. We're addressing position 14, in which he's charged with loitering and prowling. He's got an add-on case, position 3, criminal trespass, from August 8th of 2025, and position 4, criminal trespass, from February 16th, 2026. They all appear to be university property, with the exception of the trespass from August 8th, 2025, which was at a 405 Cooper Street. All right. So, Mr. Hilburn, this is going to be a non-negotiated plea hearing, which means that I'm going to hear from the prosecution, then I'm going to hear from your attorney. I will make a decision as to which option I'm going to select. I also have the option of rejecting both plea offers, both recommendations, and to schedule this case for trial. So, Mr. Scirocco, what was the plea offer for all three cases?
Yes, Your Honor. For positions 14 and then add-ons 3 and 4, the position 14 case, the state was recommending for the loiter prowl, 12 months served 60 days, credit for time served, balance probated, stay away from all Georgia Tech premises and property. And count 2, the giving false information, 12 months probation concurrent with count 1, 20 hours community service. For the add-on 3 criminal trespass case, 12 months probation concurrent with the position 14 case. Stay away from 405 Cooper Street in Atlanta, and 20 hours community service on that. For criminal trespass, the other criminal trespass add-on 4, 12 months probation concurrent with position 14's case. Social worker visit for housing, stay away from all Georgia State University premises and property, and 20 hours community service for a total of 12 months served, 60 days, credit for time served. Stay away from the locations, a total of 60 hours community service. And I believe that is what the state had for as far as offers go. The with respect to the position 14 case, that was he was located on Georgia Tech's property, pulling on bikes at the bike rack, April 22nd, 2026.
We'll be stipulating all the bases.
This is a
It's a
non-negotiated.
non-negotiated plea.
It's
Yeah.
non-negotiated. The state has a right to allocate the factual basis. Go ahead.
As I was saying, he was located on the Georgia Tech campus, pulling at bikes on the bike rack on that date. This was at almost 2 in the morning near one of the dining halls, and he gave the responding officer the false name of Philip Brandon Hilburn, when his name is certainly Reginald Hilburn. Also gave a false date of birth. The August 8th criminal trespass, that was there was a response to the Prowler call that law enforcement received at the Buckhaven construction site. Or it's not in, I don't believe it's in Buckhaven, but it's at that location in Fulton County. And they had explained that the defendant was on the site tampering with items by pulling on iron stakes and the silk fence along the construction site during construction hours and near the construction equipment, placing himself in harm's way and interfering with their property there. He was caught on drone footage doing so. And the Monday, excuse me, not Monday, the February 16th, 2026 incident was a law enforcement responded to the GSU building there on the 5th floor. He was inside, the defendant was inside that location, and he had an active criminal trespass warning, I believe, maybe multiple. Either way, he was barred from all GSU premises for a period of 2 years. And that was on that date. He had already been given a criminal trespass warning prior to that date, but now he certainly can't return if that wasn't made clear enough to him already. With respect to history, Your Honor, 23 cycles. There's with convictions, failures to appear, and violations of probation. Criminal trespass convictions, 3 from 2016 on different cases, as well as a violation of probation. There was a probation revocation, 2 in 2021 and 2017, conviction for violating probation 2020. There's a conditional discharge. There was a conditional discharge deferred case for 2019 burglary in the second case, as well as a 2019 shoplifting NOLO, 2018 battery conviction, 2018 theft by taking conviction. And there were some subsequent arrests for theft by taking and disorderly conduct, obstruction, and trespass from 2024 and 2025. Those cases were dismissed, but he has a pretty robust history nonetheless. We feel that the state's offer, 12 months or 60 days for 3 different cases here, 4 charges with the community service and the stayaways is more than reasonable, given his history and the facts here. So that's what the state's recommendation is.
Mr. White, what is the defense recommendation?
Yes, Your Honor. So Mr. Hilburn is volunteered at his church. He has also for the last 3 months been working at a car wash. So he does have family in the program, and he was attempting to get in the Georgia Works program when he was arrested. So what we're alternatively recommending is to give him credit for the time that he's already served, so no more jail time. Do 100 hours of community service, which is I believe 40 more hours than the state's asking for, and actually make it a part of his probation that he joined the Georgia Works program. He is trying. I heard most of that history was 6 to 9 to 10 years ago. So a little bit of recent stuff that was mostly dismissed. So that's what our counteroffer is, Judge. We're just asking to allow him to do time served as far as the amount of time he's done in jail, add additional 40 hours of community service, and make it a condition of his probation that he joined the Georgia Works program.
Okay. I'm inclined to agree with you, Mr. White, except that Mr. Hilburn, given his history of probation revocations, probation violations, so you're asking me to put him on probation and add more stuff for him to do. And yet I'm not sure if he's going to comply, considering the fact that within a span of 12 months, he's racked in 3 criminal trespass charges.
And Judge, I understand that there are concerns there, and if there are probation revocations, and we can hold him accountable. So, I mean, it's having someone doing additional community service and entering a program that may be beneficial for him and society is probably better than 15 days in jail is basically all we're asking. And if it doesn't work out, the court has the ability to punish him.
But we've held him accountable and he still keeps coming back. That's the part I cannot reconcile.
Judge, again, I'm not saying, like I said, most of his history was relatively a while back, but this is a new case and he's going to go on probation anyway, and we're asking for additional conditions of his probation that if he does not comply with, or if he's rearrested, he would then be brought back to jail on new charges and or revoked to do the time here. But there is a potential that he could complete the Georgia Works program and do the community service. And
how much time has he been in jail? 15 days?
15 days at this point, Judge.
All right. I will amend it to 12 months to serve 30 days, credit for time served 15 days. However, position number 14 is going to be a consecutive sentence to the other 2 cases. He will be on probation for 2 years. And he'll need to start paying probation fees from the get-go.
Okay.
Otherwise, we'll take these 3 cases to trial.
That's fine, Judge. Do you understand that, Mr. Hilburn? You're going to, instead of a year of probation, it's going to be 2, and you're going to have to pay the fees. Judge, we would ask that at least for the 2nd year, if he's completed everything, he can go non-reporting.
Absolutely not.
Or in the alternative, you could waive his fees, because, I mean, all they're going to do is take $50 from him and send him home. It's not like they're giving him any counseling or checking up on him, especially if he's completed everything. It's just about them collecting fees.
Mr. White, with all due respect, you're asking me to hold him accountable, and this is the manner in which he's going to be held accountable. The request for fee waiver is denied.
Thank you, Honor. I'm grateful for what you grant.
Oh, you're good. Just
So,
don't.
Mr. Hilburn, it will be 2 years of probation. You'll be required to pay probation fees every month. And if you fail, we will issue a probation warrant immediately, and you'll be sent to jail or to prison for up to 2 years.
Yes, ma'am.
So if you want to speak with your attorney with regards to this recommendation, you're more than welcome to do so.
I'm fine. I'm gonna get me a job, and I'm gonna get it's gonna get paid off, man.
Mr. White, would you like to speak with him, or shall I proceed?
Judge, I've spoken with him in detail a couple times over this. I think we're ready to proceed.
And do you stipulate to venue and ID, Mr. White?
We do, Judge.
With regards to Mr. Hilburn, you've already been placed under oath for this. I can't recall whether I did, so let me go ahead and do it again. Ms. Hilburn, raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
All right. Have you consumed any medicine or alcohol recently? You may put your hand down.
Yes, ma'am.
Have you consumed medicine?
Yes, ma'am.
Are you still able to understand what's going on in your cases?
Yes, ma'am.
Are you satisfied with your attorney?
Yes, ma'am.
Has your attorney explained to you that if you decide to plead guilty to these 3 cases, you would have to give up your right to a trial? You will not go back to face a judge or a jury. You will not be able to face your accusers, to challenge the evidence brought against you, to be able to present your own legal arguments and defenses. And the prosecution won't have to carry its burden to prove the charges beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
Let's begin with the incident from August 8th, 2025. How do you plead to criminal trespass in case 25 CR 4584F?
Guilty.
Right, this is add-on position 3. Your sentence for that particular charge is going to be 12 months to serve 30 days, credit for time served 15 days. You are to stay 200 yards away from 405 Cooper Street in Atlanta, Georgia, and you will need to complete 20 hours of community service at any nonprofit agency. It cannot be a church and it cannot be a school. With regards to the incident from February 16th, 2026, case number 26 CR 1056F, how do you plead to criminal trespass?
Guilty.
Your sentence is going to be 12 months to serve 30 days, credit for time served 15 days, and that's going to be concurrent to the add-on position 3. You are to stay away from all Georgia State University property for the term of your entire probation, which will be up to 2 years. And you are to complete an additional 20 hours of community service. And again, with not at any church and not at any school. With regards to your third case, position 14 on the calendar, 26 CR 002593F. How do you plead to loitering and prowling and giving false information to a law enforcement officer?
Guilty.
Your sentence is going to be 12 months to serve 30 days, credit for time served 15 days. This is going to be consecutive to add-on position number 4, which means there'll be an additional 12 months of probation. You'll be required to report to probation every month. You need to pay your probation fees. And in this particular case, you have to stay away from all Georgia Tech University property. Do you understand, sir?
Yes, ma'am.
And this will be for a period of up to 2 years. And you are required to do an additional 20 hours of community service. So your community service hours are a total of 60 hours, and you will complete your community service over the span of 2 years at a minimum rate of 10 hours per month.
Yes, ma'am.
You are not to consume any illegal drugs. You're not to consume any alcoholic beverages, and you're not allowed to own or possess any firearms or have any weapons.
Yes, ma'am.
You will report to probation on Monday, this coming Monday, at 132 Mitchell Street in Atlanta, Georgia, before 3 p.m. Do you understand?
Well, could you give me the directions or the address to that on a printed piece of paper, please?
Mr. White?
Ms. Hilburn, we'll have it written down for you there. Somebody write down the address. It's near the courthouse downtown.
Okay, thank you.
Mr. Hilburn, you'll be on probation for 2 years. You need to keep up with your probation fees, and you need to keep up with your community service and stay away from the universities and Cooper Street. Do you understand?
Yes, ma'am.
If you get arrested again, if you don't report to probation, and if you don't comply with these conditions, I am authorizing probation to immediately issue a probation warrant, revoke your probation, and you will serve the rest of the 2 years in prison.
Yes, ma'am.
Thank you.
Your Honor, before we move on to the next case, I have 80 hours of community service. You changed number 4 to 40 hours.
Uh,
Please change
20, I'm so sorry. Did I say 4? I meant it was an additional 20, so it's 20, 20, 20. So a total of 60 hours.
Oh, so you want 20 on number 3?
Yeah, I
too?
must have misspoke. I was adding the community service.
Okay,
So
hold
it was
on.
20,
1 second.
20, and 20.
Okay, so it's gonna stay 20. Okay.
60 hours. Sorry about that.
Okay, thank you.
Courtroom 2, next case.
We got number 15, Mr. Houston.
Oh, Miss Young, I forgot to add that for Mr. Hilburn, he'll need a social worker to address housing issues as well.
Yes, Your Honor.
Troy Houston is accused of 2 counts, one of which is simple battery, and we're going to waive sounding on count 1. We're not going to make any reference or make any statements referencing that. So, Mr. Scirocco, the proposed offer will just refer to the program as SDET.
Mhm.
Mr. Houston's case number is 26CR 2608L. And I understand this is going to be a plea hearing. So, Mr. Houston, please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Thank you. This incident date appears to be November 4th, 2025. And Mr. Scirocco, what is the plea offer for counts 1 and 2?
Your Honor, count 2, the simple battery will be null prost upon acceptance to the count 1 charge. For that count 1 charge, state's recommending 12 months, served 30 days, credit for time served, balance probated, SDET, no further contact with Marley Taylor, or excuse me, yes, Taylor. Apologies, there's a typo there. Taylor, stay away from Washington Park Branch Library. That is located at 1116 Martin Luther King Jr. Drive in Atlanta, and 40 hours community service. We did speak with the victim. He is in agreement with the state's offer. If we could sound for him.
Marley Taylor, if you're on Zoom, you can chime in at the present time.
Yes, ma'am.
I don't hear a Marley Taylor. So, okay. Mr. White, does your client accept the terms and do you so stipulate?
We do stipulate and accept the terms, Judge. We would just ask that this probation go to non-reporting once it completes the requirements and waive
Denied?
and
Not
waive
under these. I'm sorry, go ahead.
and waive 4 months of fees. The program that he's required to do is actually quite expensive, and he has no income at this point. So we waive as many months of probation as we can get. I mean, fees.
I will waive probation fees for 3 months as long as he enrolls into that program within 90 days. Please unmute courtroom 2.
Yes, ma'am.
If you don't enroll in the program within 90 days, then we will reinstate those 3 months of fees that have been waived.
Yes, ma'am.
Mr. White, shall I proceed?
Yes, Judge.
Okay. Mr. Houston, have you consumed any alcohol or medicine recently?
No, ma'am.
Have you understood what's going on in your case?
Yes, ma'am.
And are you satisfied with your attorney?
Yes, ma'am.
If you decide to plead guilty to count 1, you would have to give up your right to a trial before a judge or a jury. You won't go back to a courtroom to face a judge or jury with regards to this case. You will not be able to challenge the evidence that will be brought against you, to face your accuser, and the prosecution won't have to prove the charges beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to count 1?
Guilty.
Your sentence is going to be 12 months to serve 30 days, credit for time served. You will report to Fulton County Probation within 48 hours on the first business day before 3 p.m. While you're on probation, I will waive your 3 months, your first 3 months of probation fees, as long as you enroll in the SD program and submit yourself to an evaluation and comply with all the treatment that's required. At all times, you will have no contact with Marley Taylor, and you are to stay away from the Washington Park Branch Library, located at 1116 Martin Luther King Jr. Drive in Atlanta, Georgia. You'll also be required to do 40 hours of voluntary community service at a minimum rate of 10 hours per month. Once the 3 months fee waiver is over and there's proof that you've enrolled in the program, you will also start paying probation fees from month 4 onwards. You will report to probation every month until your probation term is completed with succession. Thank you.
Item 16 and 17, Mr. Jackson.
Mr. Young, count 2 for Mr. Houston is null prost.
Thank you.
How you doing?
Hi, I'm fine, thank you. This is Aussie Jackson, accused of theft by shoplifting from April 21st of this year, case 25 CR 2092C. And he's got a bench warrant from June 2nd of 2025, 26 FTA 770. You've been advised of your rights. Your attorney is Mr. White. May I place you under oath for the plea? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, yes.
Was that a yes?
Yes,
Thank
yeah.
you. All right, Mr. Skaraka?
Yes, Your Honor. For position 16, the theft by shoplifting, state's recommendation is 12 months or 30 days, credit for time served, balance probated, anti-theft course, $500 fine, stay away from the Family Dollar that is located at 2045 Donald Lee Hollowell Parkway in Atlanta. And upon acceptance of the plea there, the state will null prize position 17, the FTA. We would ask that defense stipulate the factual basis, venue, and ID for purposes of the plea.
Stipulated. We would ask to convert the $500 fine to 50 hours of community service and waive the first 2 months of his probation fees.
Just give me a moment. Miss Hutchison, how many cycles does Mr. Jackson have? Are there any prior theft by shopliftings? I'm sorry, Miss Hutchison, are you available?
I might be able to confirm, Judge.
Okay.
Let me look. This was prepared by another attorney here, so let me see.
He had a $5,000 signature bond, so I'm curious to know why it was that high.
It looks like I don't see prior shoplifting convictions per se. So that $500 is not statutory. I do see it looks like an open theft by shoplifting case, presumably out of DeKalb from 2024. And it looks like there's an open theft by shoplifting case out of Atlanta Municipal. So presumably that's why the bond was set as it was, Judge.
Mr. White, I can amend the $500 fine to a $250 fine plus 25 hours of community service. And he would need to report to probation every month, and his fee waiver is denied. Would he still like to proceed?
Judge, the plea, these are just relief that we're asking for going forward with the pleas. So yes, we would still like to go forward with the plea.
Okay. Mr. Jackson, have you consumed any, I'm sorry, do you stipulate to the factual basis, venue and ID? I'm sorry, you might have said yes. I apologize.
Yes, Your Honor.
No, that was Mr. White. Mr. White, did you so stipulate? Sorry.
Yes, Judge, we do stipulate for the purpose of the plea. I'm not sure if I answered that or not.
Mr. Jackson, have you consumed any medicine or alcohol or both recently?
Medicine.
Okay. Are you still able to understand what's going on in both your cases?
Yes, Your Honor.
And are you satisfied with your attorney?
Yes, Your Honor.
If you decide to plead guilty to this charge of theft by shoplifting, you would have to give up your right to a trial. You will not go back to a courtroom to face your accuser, challenge the evidence brought against you, have the assistance of counsel to present your legal defenses and arguments, and have the state prove the charges beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, Your Honor.
How do you plead to theft by shoplifting on April 21st of last year?
Guilty.
Your sentence is going to be 12 months to serve 30 days, credit for time served, balance probated. You will report to Fulton County Probation within 48 hours of being released, and it will be on the first available business day. You within 30 days of being released, you will enroll in an anti-theft class and show proof of enrollment to your probation officer. You will pay a $250 fine at a minimum rate of $25 per month, and you will complete 25 hours of community service with any nonprofit agency that's not a church and not a school. And you will complete your community service at a minimum rate of 5 hours per month. At all times, you're to stay away from the Family Dollar store at 2045 Donald Lee Hollowell Parkway in Atlanta, Georgia. You will report to probation every month for the term of your probation, and you will be current with your probation fees at all times. Thank you.
You. And that's
His
got,
bench warrants dismissed.
that's got 20, Mr. Jones.
Jamarian Jones is accused of the following 3 offenses: 2 counts of possession and use of drug-related objects, loitering and prowling from November 9th of 2025, case number 26 CR 2313G. Mr. Jones has been advised of his rights, and I understand this is going to be a plea hearing. Mr. Jones, please raise your right hand for the plea. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yeah, ma'am.
Thank you. Mr. Scaraco?
Yes. Quick inquiry. This is Mr. White or Mr. Haddad's case?
It's fine.
Is for count 3, the op 21 or the 15? It was we had given the option.
Right, and the 15 hours of community service.
Okay, thank you. Your Honor, for position 20, possession, use of drug-related objects, and loiter, prowl. Count 1, the drug-related objects, state's recommendation is 12 months, served 60 days, credit for time served, balance probated, ADET. Stay away from the 6295 Oakley Road address in Union City, that being the Oakley Shoals apartment complex. Count 2, the other count of possession, use of drug-related objects, will null pros upon acceptance of the pleas here today. And for the loiter prowl, the state's recommending 12 months probation concurrent with count 1 and 15 hours community service. We would ask that defense stipulate a factual basis, venue, and ID for purposes of the plea. That should be all for the state.
So stipulated, Your Honor.
Miss, go ahead. Anything else?
Judge, we were just going to ask that his probation go to non-reporting once he completes all of his requirements and waive the first 2 months of probation fees.
Any objection to non-reporting?
Yes, Judge, I do see several probation violations, 2026, 2025, 2015. He's got 3 open felony cases, one of which involves involves drugs, and that being the possession of the cocaine. And this was, I believe, downgraded from a felony involving crack cocaine possession. And so now it's here in our court. The state would object to non-reporting.
I will waive I will waive the first month of fees, but he'll be required to report every month. Would he still like to proceed?
Judge, yes, we would still like to proceed.
Mr. Jones, have you consumed any medicine or alcohol recently?
No.
Sorry, I can't hear you. Still can't hear you.
Oh, ma'am.
Okay. And have you understood what's going on in your case?
Yes, ma'am.
Are you satisfied with your attorney?
Yes, ma'am.
I'm sorry, the audio is not very clear from the courtroom, but you'll need to speak up, okay? And has it been explained to you that if you decide to plead guilty to these charges, you would have to give up your right to a trial? You will not go back to a court to face your accuser. You will also not get a chance to confront and challenge the evidence brought against you, present your own defenses and arguments, and the prosecution won't have to prove the charges beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to one count of possession and use of drug-related object and one count of loitering or prowling?
Yes.
For the count one, it's going to be 12 months to serve 60 days, credit for time served, balance probated. Within 10 days of reporting to probation, you will undergo an alcohol and drug evaluation and submit to all treatment that's required. You will also stay away from the entire Oakley Shoals apartment complex at 6295 Oakley Road in Union City. Count 2 is dismissed. Count 3, with regards to the loitering and prowling, is going to be 12 months concurrent with count 1, where you'll be required to complete 15 hours of voluntary community service hours at a minimum rate of 3 hours per month. At any nonprofit agency, cannot be a church, and it cannot be a school. You will report to probation every month and be current with your probation fees at all times. I will waive your probation fees for the first month. You will also be subject to random screens for illegal drugs. If you consume any illegal drugs and you test positive, your probation will be revoked. Thank you.
I got other probation, so when I do get out, do I just report to the new probation?
You report to Fulton County Probation for this case. They will advise you about your other probation obligations. You can ask them then.
All right, then we got 2122, Mr. Karim.
Is that your case, Mr. White?
It is, Judge.
Thank you. Malik Karim is accused of criminal trespass, loitering or prowling, possession and use of a drug-related object, and theft by taking under accusation 25 CR 2280B. And this is from March 9th of 2024. He has a bench warrant under 26 FTA 793 from February 9th, 2026. Mr. Karim, you've been advised of your rights. Your attorney is Mr. White. May I place you under oath for this plea? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge? Repeat. Thank you. Mr. Scirocco?
Yes, Your Honor. The state's recommendations for position 21 on the criminal trespass, 12 months probation concurrent with count 4, stay away from 368 Angier Avenue in Atlanta, 20 hours community service. For the loiter prowl, 12 months probation concurrent with count 4, stay away from 368 Angier Avenue in Atlanta, 20 hours community service. Count 3, 12 months probation concurrent with count 4. This is for the drug-related objects. ADET, stay away from 395 Linden Avenue in Atlanta. No illegal drugs. And for count 4, the theft by taking, 12 months, serve 132 days, credit for time served, balance probated. Anti-theft course, no further contact with Mr. Kenneth Harper. And stay away from 395 Linden Avenue in Atlanta. We would ask that defense stipulate the factual basis, venue, and ID for purposes of the plea, and we would object to any non-reporting here. And
Mr.
if we
White?
could sound for Mr. Harper, excuse me.
Oh, I'm sorry. That was
Kenneth Harper, Your
Kenneth
Honor.
Harper. Kenneth Harper, if you are on Zoom and want to address this case, please unmute and start your video. All right, Mr. White?
Your Honor, we do stipulate for the purposes of the plea. And we would ask for a fee waiver of 2 months, if at all possible. And then his probation go to non-reporting once he completes all of his requirements.
His fee waiver will be granted upon his enrollment in an anti-theft class within 60 days of reporting to probation. If he doesn't enroll in the program, the waived fees will be reinstated. Is that acceptable, Mr. Karim? Sorry?
Yes, ma'am.
Okay. All right. Mr. Karim, have you consumed any medicine or alcohol recently?
Ma'am.
Have you understood what's going on in your cases?
Yes, ma'am.
And are you satisfied with your attorney?
Yes, ma'am.
If you decide to plead guilty to these charges, you would have to give up your right to a trial. You will not face a judge or jury in a court of law, not be able to confront your accuser, challenge the evidence brought against you, present your own defenses and arguments through an attorney, and have the state prove the charges beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to criminal trespass, loitering or prowling, possession and use of drug-related objects, and theft by taking?
Guilty.
Your sentence for count 1 is going to be 12 months concurrent with count 4. Stay away from 368 Angier Avenue in Atlanta and complete 20 hours of community service with any nonprofit agency that's not a church and not a school. Count 2 is going to be 12 months concurrent with count 4. Again, stay away from the Angier Avenue location and complete an additional 20 hours of community service. Count 3 is 12 months concurrent with count 4. You are to enroll in an alcohol and drug evaluation within 10 days of being released and comply with all the treatment and counseling that's required. In this count 3, you're to stay away from 395 Linden Avenue in Atlanta, Georgia. For the entire time that you're on probation, you're not allowed to consume any illegal drugs, including marijuana. For count 4, theft by taking, your sentence is 12 months to serve 132 days, credit for time served, balance probated. I will waive your first 2 months of probation fees as long as you enroll in an anti-theft course within 60 days of your first report date. At all times, you're to have no contact with Kenneth Harper and stay away again from the Linden Avenue location. You will be subject to random screens for drugs, illegal drugs, including marijuana. And if you fail a drug screen, you get arrested again. Or if you violate any of the conditions of probation, probation is authorized to revoke and have you serve out the rest of the time in jail. Thank you. His bench warrants dismissed.
23 through 26, Mr. Kilgore.
This is a
Okay.
negotiated plea.
Okay. All right, out of these 4 cases, 2 are bench warrants regarding Mr. Reginald Kilgore. Position 24 is a bench warrant from November 7th, 2025, 26 FTA 789, and 20, that was position 24. Position 25 is a bench warrant for the second case, also from November 7th, and that's 26 FTA 790. And his 2 other cases, position 23 is battery family violence from case 25 CR 4089E from June 4th, 2025. And the 4th case is accusation 22 CR 2784E, fair evasion and criminal trespass at Marta property from May 6, 2022. Mr. Kilgore, may I place you under oath for your plea? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Ma'am.
Mr. Scirocco?
Yes, Your Honor. For position 23, the battery family violence state's recommendation is 12 months served, 26 days, credit for time served, balance probated, recommending FFIB, as well as 20 hours community service. No further contact with Ashanti Barber. Stay away from 2040 Stanton Road in East Point, and no firearms. For 26, the fair evasion and criminal trespass. On count one, the state's recommendation is 12 months probation concurrent with count two, 20 hours community service. And for count two, the criminal trespass, 12 months probation concurrent with the 25 CR 004089E case. Comply with any active MARTA bans or suspensions. 20 hours community service there for a total of 60 hours community service between the cases. Upon acceptance of the pleas here to the offenses, state will null pros the FTA's positions 24 and 25. We would ask that defense stipulate the factual basis, venue, and ID for purposes of the plea. And if we could sound for Ashanti Barber at this time, Your Honor.
Ms. Barber, Ashanti Barber, if you're on Zoom, this is the time to unmute and start your video. All right, Mr. White?
Your Honor, we do stipulate for the purposes of the plea. We would ask that the probation fees be waived for the first 2 months. Also ask that his probation go to non-reporting once he completes all of his requirements. We point out that one of these cases is 4 years old as of yesterday, and one will be a year old next month. So we're just asking for fee waivers and non-reporting once everything's completed.
I will waive the fees for the first 2 months as long as he enrolls in the domestic violence intervention program within 60 days of being released. If he doesn't enroll, then the fees will be reinstated. Is that acceptable, Mr. Kilgore?
Yes, ma'am. Hey, can I say this? I don't stay at my mom's. My mail address is just at my mom's house. Is it something? Is it some way? Can I get I just got a town. Can I get my address changed? That's the reason why I missed court, because I couldn't get mine. My mom and them would not call me or tell me that I had court. So all I'm asking, go ahead.
Kilgore, this isn't, so as far as notice, anything like that, that doesn't apply to these cases anymore. Like we talked about yesterday, if you do need to change your address, you need to go to the clerk's office for anything that may come down the pike in the future.
Yes, sir.
Okay.
All right. Mr. Kilgore, have you consumed any medicine or alcohol recently?
Oh, ma'am.
Have you understood what's going on in all your 4 cases now?
Yes, ma'am.
And are you satisfied with your legal services?
Yes, ma'am.
If you decide to plead guilty to 2 of these cases, you would have to give up your right to a trial. You will not go back to court to face a judge or a jury. You will not be able to challenge any evidence that will be brought against you, and you won't be able to confront the accusers in these cases. Furthermore, the prosecutor won't have to prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to battery family violence from June 4th, 2025 in position 23?
Guilty.
Your sentence is going to be 12 months to serve 26 days, credit for time served. Within 48 hours of being released, you will report to probation on the first available business day before 3 p.m. I will waive your first 2 months of probation fees as long as you enroll in a domestic violence intervention program within 60 days of your first report date. This is a program involving 24 weeks of classes, and you need to complete all these classes without missing or skipping any of these classes, and you need to pay for these classes out of your own pocket. You'll be required to do 20 hours of community service at any nonprofit agency, but it cannot be a church and it cannot be a school. At all times, you are to have no contact with Ashanti Barber, and you're to stay away from 2040 Stanton Road in East Point. You're not allowed to own or possess any firearms. You will report to probation every month until the remainder of your 12 months is completed. On position 26, how do you plead to fair evasion and criminal trespass at Marta property?
Guilty.
For the fair evasion, it will be 12 months probation concurrent with count 2 of this case, where you will do an additional 60 hours of community service. With regards to the criminal trespass, it's going to be 12 months concurrent with the case from position 23. And you'll report to probation every month, and you will stay away from all Marta property in accordance with any active current suspension. If you're not sure, you should contact Marta Police through the phone and confirm to see whether you have any active suspension. If so, you are required to stay away from all Marta property. You're also required to do an additional 20 hours of community service. In total, your obligation is 60 hours of community service, which you will complete at a minimum rate of 10 hours per month.
Yes, ma'am.
Thank you. Oh, his 2 bench warrants are dismissed.
All right, this guy 2930, Mr. Martin. Yep. Come on.
No. Antoine Martin's case is 24 CR 4093H, is accused of theft by shoplifting, willful obstruction of an officer, and criminal trespass. This is allegedly at Georgia Tech property from June 14th, 2024. He has a bench warrant from February 28th, 2025, 26 FTA 769. Mr. Martin, you've been advised of your rights, and may I place you under oath for this plea? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, I do.
Thank you. Mr. Scirocco?
Yes, Your Honor. For count 1, the theft by shoplifting, the state's recommendation is 12 months served, 114 days, balance probated, complete an anti-theft course, $500 fine, stay away from Georgia Tech premises and property. For count 2, the obstruction, 12 months probation concurrent with count 1, $300 fine. And for the criminal trespass, count 3, 12 months probation concurrent with count 1, 40 hours community service. For a total of $800 in fines and 40 hours community service, as well as the anti-theft and the stay away. The states agreed to null pros the failure to appear for position 30 upon acceptance of the plea here. We would ask that defense stipulate a factual basis, venue, and ID for purposes of the plea. We would certainly object to any sort of non-reporting here upon completion of the conditions.
Mr. White?
Judge, we do stipulate for the purposes of the plea. Again, we ask that the $500 fine be converted to 50 hours of community service. The $300 fine. So a total of 120 hours of community service. And as it is, this case is almost 2 years old. As it is probation, go to non-reporting once he completes all of his requirements.
Any objection?
Yes, Your Honor. Recent convictions for criminal trespass, terroristic threats and acts, felony terroristic threats and acts, theft by shoplifting conviction 2023. And I see as far as criminal trespass, 2 NOLOs, 2022, 2017, as well as a conviction from 2024, and 2 convictions for simple assault, 2024, 2023, NOLO 2017. Battery conviction 2024 and a theft by taking conviction 2021 with probation violations from 2024 to and 2022. He also has a foreign county hold, I think.
And does he, well, like you just answered my question, he has a hold. Okay. On the I guess on the $500 fine, I will amend that to 50 hours of community service So that would be a total of 90 hours of community service. The willful obstruction, the $300 fine stays. He would need to pay a fine and complete his community service and report every month and be up to date with his probation fees before he goes non-reporting. Is that acceptable, Mr. White?
Yes, Your Honor.
Mr. Martin, have you consumed any medicine or alcohol recently?
Yes, ma'am.
And are you still able to understand what's going on in your two cases?
Yes, ma'am. Okay.
Do you understand that if you decide, I'm sorry, are you satisfied with your attorney?
Yes, ma'am.
All right. So do you understand that if you take a guilty plea today, once you have resolved all your other cases and any other holds that you have, you're required to report to probation within 48 hours of being released?
Yes, ma'am.
All right. So once you're on probation, then you would need to commence with the filling the obligations. So let's proceed. Has it been explained to you that if you plead guilty, you would have to give up your right to a trial?
Yes, ma'am.
And that means that you won't be able to go back to a courtroom to face a judge or jury, to be able to challenge the charges brought against you, confront your accuser, and have the state prove the charges beyond a reasonable doubt. You understand all that?
Yes, ma'am.
And you're prepared to give up these rights?
Yes, ma'am.
Okay. How do you plead to theft by shoplifting, willful obstruction of an officer, and criminal trespass?
Yes.
I'm sorry?
Yes.
How do you plead?
He did say guilty.
Guilty.
Oh,
Can you hear me?
No.
I said guilty.
Okay. On the theft by shoplifting, your sentence is going to be 12 months to serve 114 days, balance probated. You would need to do an anti-theft course and you need to enroll in the class within 60 days of your first report date. You are to complete 50 hours of community service at any nonprofit agency, cannot be a church and cannot be a school. And at all times, you are not allowed to return to Georgia Tech property. On count 2, the obstruction, your sentence is going to be 12 months concurrent with count 1, and you need to pay a $300 fine at a minimum rate of $50 per month. And on count 3, the 12 months is going to be for the criminal trespass. It's going to be 12 months probation concurrent with count 1, and you're to complete 40 hours of community service. You report to probation every month. You pay your fine of $300 at a minimum rate of $50 per month. And you complete your 90 hours of community service at a minimum rate of 15 hours per month. Your probation will be non-reporting if you have completed full payment of your fines, you have completed all your community service satisfactorily, you're up to date with all your probation fees, and you've not been arrested and not violated any of the conditions of probation. Thank you.
All right, we have 31, Mr. Macintosh.
His bench warrant is null crossed. Macintosh. Mr. White, how are we proceeding?
it's a plea, Judge.
Benny Macintosh, case 26 CR 2645J, is accused of criminal trespass and willful obstruction of an officer from April 24th of this year. You've been advised of your rights. May I place you under oath? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes.
Mr. Scirocco?
Yes, Your Honor, the state's recommendation for the criminal trespass, count 1 is 12 months served 60 days, credit for time served, balance probated. Stay away from 3900 Fulton Industrial Boulevard in Atlanta, that is the Quality Inn and Suites. As for count 2, the willful obstruction, 12 months probation concurrent with count 1 and a $300 fine. The state would ask the defense stipulate the factual basis, venue, and ID for purposes of the plea.
We can
Mr. Wright?
stipulate for the purposes of the plea, Your Honor. We would ask to convert the $300 fine to 30 hours of community service and ask that his probation go to non-reporting once he completes that either fine or community service.
Okay. I'll amend that to a $150 fine plus 15 hours of community service. It will be non-reporting as long as he completes all the conditions and his probation fees are up to date. Is that acceptable, Mr. Macintosh?
Yes, ma'am.
Have you consumed any medicine or alcohol recently?
No.
Have you understood what's going on in your case?
Yes.
And are you satisfied with your attorney? Are you satisfied with the legal services you received from Mr. White?
Yes.
I can't hear you.
Yes.
If you decide to plead guilty to these charges, you would have to give up your right to a trial. You will not go back to a court of law to face a judge or jury, to confront your accuser, challenge evidence brought against you, have your attorney present your legal defenses and arguments, and the state won't have to prove the charges beyond a reasonable doubt. Are you prepared to give up these rights?
Yes.
How do you plead to criminal trespass and willful obstruction of an officer?
Yes.
Your sentence for the trespass is 12 months to serve 60 days, credit for time served, balance probated. You are to report to probation within 48 hours of being released on the first available business day. At all times, you have to stay away from the Quality Inn and Suites at 3900 Fulton Industrial Boulevard in Atlanta, Georgia. For the obstruction, your sentence is 12 months probation concurrent with count 1. You pay a $150 fine at a minimum rate of $20 per month, and you are to complete 15 hours of community service at a minimum rate of 5 hours per month. Your probation may be non-reporting as long as you complete the community service, you pay off your fine in full, and you are up to date with all your probation fees. Thank you.
Okay. All right, this is 20. Oh, no. 37, 38, and add on number 6, Mr. Reynolds.
Brian Reynolds has 3 matters before the court. Position 37 is a bench warrant from April 29th, 2026, case number 26 FTA 794. Mr. Reynolds has a charge of willful obstruction of an officer from July 4th, 2025, case 25 CR 3774H. And he's got a third case, 26 CR 2745H. Charges are 3 counts of battery family violence and 1 count of simple battery family violence from September 22nd, 2025. You've been advised of your rights. Mr. Haddad, how are we proceeding?
Your Honor, it's gonna be a negotiated plea. I would just ask the court to consider waiving the first 2 months of probation fees, Judge.
All right, I'll consider that. Mr. Scirocco, I'm sorry, Mr. Reynolds, please raise your right hand for purposes of the plea. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Mr. Scirocco, what are the recommendations for 38 and add-on 6?
Yes, Your Honor, for position 38, the obstruction, I'll say this since we're going in order. Position 37, state will null pros the FTA upon acceptance of the plea here today. For 38, position 38, the obstruction, the state's recommendation is 12 months probation concurrent with 26 CR 002745H, and a $300 fine. And for that case, ending in 2745H, the add-on 6 position, battery family violence, the state's recommendation is 12 months, serve 30 days, credit for time served, balance probated, no further contact with Jamiah Sullivan, stay away from 302 Decatur Street in Atlanta, as well as 40 hours community service and no firearms. Counts 2 through 4 would merge with count 1, and we would ask that defense stipulate the factual basis, venue, and ID for purposes of the plea, and if we could also sound for Ms. Sullivan at this time.
Jemiah Sullivan, if you want to address the court, please unmute and start your video. All right, Mr. Haddad, do you so stipulate?
Stipulate, Judge, and as requested before, court to consider waiving the first 2 months of probation fees. According to my calculations, you'll have another 6 days in custody, Judge.
Okay. I will grant the 2 months probation fee waiver as long as he enrolls into the Family Violence Intervention Program within 60 days of his first report date.
Thank you, Judge.
If he does not enroll in the program within 60 days, his probation 2 months waiver will be reinstated back into his account. Is that acceptable?
It is, Judge.
All right. Mr. Reynolds, have you consumed any medicine or alcohol recently?
No, ma'am.
Have you understood what's going on in your cases?
Yes, ma'am.
Are you satisfied with your attorney? I'm sorry?
Yes, ma'am.
If you decide to plead guilty today, you would have to give up your right to a trial. You will not go back to a courtroom to face a judge or a jury, to face your accusers, challenge the charges brought against you, present your own legal defenses and arguments, and have the state prove the charges beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to willful obstruction of a law enforcement officer from July 4th, 2025?
Guilty.
Your sentence will be 12 months concurrent with your other case, and there will be a $300 fine that you would need to pay at a minimum rate of $50 per month. How do you plead to 1 count of battery family violence from September 22nd, 2025?
Guilty.
Your sentence for the battery family violence is going to be 12 months to serve 30 days, credit for time served, balance probated. You will report to probation within 48 hours of being released on the first available business day. I will waive your first 2 months of probation fees as long as you enroll in a domestic violence intervention program within 60 days of your first report date. If you fail to do so, those 2 months of probation fees will be reinstated. At all times while you're on probation, you have to have no contact with Jemiah Sullivan. You have to stay 200 yards away from her and not communicate with her in any way, form, or manner. You have to stay away from 302 Decatur Street in Atlanta, Georgia. You're also required to complete 40 hours of community service at a minimum rate of 5 hours per month. At all times, you're not allowed to own or possess any firearms. Counts 2, 3, and 4 will merge into count 1, and his bench warrants dismissed. Thank you.
Thank you, Judge.
And that's the add on 1 and 2, but you.
I don't think.
I'm sorry, Deputy, what happened to add-on 1 and 2?
He's coming up.
Okay.
Your Honor, on position number 1, that is going to be a plea, Judge. I'm requesting, in lieu of a fine, to do 50 hours community service, Judge. And I'm also requesting a couple waiver of the first 2 months probation fees and non-report. At the appropriate time, Judge, I'll mention it. I mean, we're in agreement with the time served. I'm just asking the fine to be converted to community service.
Could I get the position numbers again? Thank you.
Add-on 1 and add-on 2. Add-on 2 is a bench warrant.
Okay.
It's a failure to appear 26 FTA 804 from September 3rd, 2025. And add-on position 1 is 24 CR 8104F, accused of theft by shoplifting from April 5th, 2022. Mr. Fuchs, you've been advised of your rights. Your attorney is Mr. Haddad. May I place you under oath for the plea? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes.
Mr. Swaraka, if you're ready.
Yes, Your Honor. For the theft by shoplifting, add-on 1, state's recommendation is 12 months or 46 days, credit for time served, balance probated, anti-theft course, $500 fine, stay away from the BP gas station at 343 Joseph E. Lowry Boulevard in Atlanta, and upon acceptance of the plea for the add-on 1, state will null pros the FTA. We are fine with this going non-reporting upon completion of the terms here, Judge.
Mr. Haddad, I will waive the first 2 months of probation fees as long as he enrolls in the anti-theft class within 60 days of his first report date. And as long as he completes all his conditions, doesn't get arrested again, and is up to date with his probation fees, if any, then the case may go non-reporting.
Let me just explain real quick, Judge.
Okay? We can mute courtroom 2, please. Oh, and I will amend the $500 fine to 50 hours of community service. Sorry about that.
That was the question. All right, then I spoke to my client. We're ready to proceed as the court had announced, Judge.
Mr. Fuchs, have you consumed any medicine or alcohol recently?
No.
Have you understood what's going on in your cases?
Yes.
And are you satisfied with your attorney? Repeat.
Yes.
If
Yes.
you decide to plead guilty to this charge, you would have to give up your right to a trial. You will not be able to go back to a courtroom to face your accuser, challenge the evidence that we presented against you, present your own legal defenses and arguments, and the state won't have to prove the charge beyond a reasonable doubt. Are you prepared to give up these rights?
Yes.
How do you plead to 1 count of theft by shoplifting from 2022?
Guilty.
Your sentence is going to be 12 months to serve 46 days, credit for time served, balance probated. You will report to probation within 48 hours of being released on the first available business day. While on probation, I will waive your 2 months of probation fees as long as you enroll in the anti-theft course within 60 days of the first report date. Your $500 fine is amended to 50 hours of voluntary community service, and you can perform that community service at any nonprofit agency, but it cannot be a church and it cannot be a school. You will do your community service at a minimum rate of 10 hours per month. At all times, you do not return to the BP gas station. You stay 200 yards away from that location, which is 343 Joseph E. Lowry Boulevard in Atlanta, Georgia. If you have completed the community service, if you have completed the anti-theft class, and you are up to date with any probation fees that are incurred, then your probation will be non-reporting.
Thank you, Judge.
All right, going back to number 12, Mr. Hamilton.
The court is calling for Mr. Jacoby Hudson. All right, Mr. Jacoby Hudson has not reported back to court. I gather he still is in DeKalb County. Miss Young or Miss Champion, is Mr. Hudson in the waiting room by any chance?
No, ma'am, he is not.
Okay. Mr. Detovius Hamilton, I gather you should contact your attorney. This case is going to be reset to next Thursday, May 12th. May 14th, excuse me. Let me see this. Can we put it on May 12th by any chance, Miss Champion or Miss Young? Just because of the plea offer doesn't require additional jail time.
Yes, ma'am, we can.
All right, so it'll be next Tuesday, and hopefully your attorney will appear. Deputy, next case.
And that's it. I think we're caught up, Judge.
Okay, sir. Just to go over the calendar, I'm going to start with the add-on calendar. Position 1 was a plea. Position 2 is null prost. Position 3 and 4 were pleas. Position 5, Perry Long, is reset to SAP May 19. Position 6, Brian Reynolds, was a plea. And position 7, Thomas Stevens, what are we doing?
So waiver, not guilty, Judge.
All right, sir. This case is going to be further notice for jail jury. On the main SAP calendar, position 1, Achelis, is a plea. Position 2 was a plea. Position 3, Quintavious Andrews, is further notice. Bond was modified to a signature bond through pretrial level 2. Position 4, Bonner, is a waiver of arraignment and further notice for trial, along with position 5, waiver of arraignment. Position 6, Mr. Boozer was a plea. Position 7 is null pros. Position 8, Kenyatta Brown, is reset to SAP on May 14. Position 9, Chantel Clark, is a waiver of arraignment and further notice. Bond was modified to a split bond. Position 10, Crumbley, is a waiver of arraignment and further notice jail jury. Bond modification was denied. Position 11, Dinard, is a waiver of arraignment and
Yeah, it
what
was.
further notice jail jury? Okay, thank you. Position 12 is reset to Tuesday, SAP May 12, for counsel to appear. Position 13, Harold's a plea. 14, Mr. Hilburn was also a plea in addition to his add-on cases.
Oh, before you proceed, Your Honor, the for position, it's for 12, Mr. Hamilton, he's actually, it wouldn't be, from my understanding, a time served plea. He's not being held on our charge. He's being held on a felony FTA.
Okay. But I'll still reset it to May 12th in case he wants to. I don't know what Mr.
Sounds good.
Hamilton
I
wants
just wanted to let you know.
Thank you. So again, position 14 was a plea. Position 15 was a plea. 16 was a plea. 17 was a plea. 18, Joyner, was a bond modification that's going to be further notice jail jury. Further notice for trial. And that was a modification to a 3,000 signature bond through pretrial level 3. Position 19, bond was amended to a 4,000 signature bond through pretrial level 3, pending the status on diversion. So that's further notice for trial. Position 20, Jamarian Jones, was a plea. 21 was a plea. 22 was null pros. 23 was a plea. 24 was null pros. 25 was null pros. 26 was a plea. 27 is reset to the SAP calendar. Oh, that was Perry Long with the add-on. Was that the same Perry Long?
Yes, yes, Judge.
Oh, so that is reset to May 19 SAP, excuse me. Position 28, Kayana Lyons was released, so that's further notice. Antoine Martin was a plea. Position 30 is null pros. 31 is a plea. 32, Middlebrooks was released on May 3rd. 33 was a waiver of arraignment, further notice jail jury. 34, Morgan, is a state reset to May 14th, next Thursday. Same announcement for position 35, reset May 14, as well as 36, May 14th. 37, Brian Reynolds was null pros. He took a plea on position 38. Position 39 was a plea. 40 was null pros. 41, 42, 43 were pleas for Myron Shay, and 44 was null pros. 45, Thomas Stevens, that's a waiver of arraignment, correct?
That's correct, Judge.
All right, so that's a waiver and further notice jail jury. Quinlan Thomas is a waiver of arraignment, further notice jail jury,
That
same
was a
announced.
felony transfer accepted. I'll be sending Your Honor the for these cases for Quinlan Thomas 46 and 47. I'll have the order for your signature, Judge.
All right, thank you, sir. So positions 46, 47 are going to be a felony transfer to Superior Court. 48, Thompson was a plea, and 49 was null pros. Philip Tomes was released on May 2nd. 51, David Wells.
It's a waiver, not guilty, Judge.
All right, that's going to be further notice jail jury. 52 and 53, Bertha Williams is reset to May 21st. 54, Mark Williams is a waiver of arraignment for the notice jail jury. Same announcement for 55, waiver of arraignment for the notice jail jury. I do not have a probation calendar and I do not have a DV calendar, correct?
I believe so, Judge.
All right. We're going to carry on to our 11 a.m. competency calendar. Is Mr. Bartel joining us, Mr. Haddad, or would you be handling that?
Well, 1 week is enough, Judge.
All right, thank you. Oh,
Your Honor,
Good morning,
yes,
Judge.
Mr. White?
before we proceed, position 1 and 2, you announced as pleas. Those are actually waivers.
You're correct. I'm so sorry. I thought they were going to be a plea, but this is going to be a waiver of arraignment. Frido Achelis was a waiver of arraignment?
That's correct, Judge. It started as a plea and then
You're right. Sorry about that. Waiver arraignment for the notice jail jury. Okay.
Your
And
Honor,
this-
could you tell me about position 16? Did we waive anything or non-reporting? That's the only part that I missed.
This is Aussie Jackson. Her fine was amended to $250 fine plus 25 hours community service. There was no other waiver or anything.
Okay, thank you.
Mhm.
I'm saying like waive probation fees or anything. I missed
I
that.
don't believe so.
Okay. I just wanted to make sure. That's the only question that I had. Your
Okay.
Honor, iPhone is raising her hand for Mark Williams. I've been trying to explain to her.
That's fine. I was going to address that shortly. I just
Thank
want to
you.
make sure that all the other announcements on the calendar were correct.
And Judge, good morning.
Morning?
Just to let y'all know, we're gonna have at least one plea. I've talked to one person and have a couple of other clients to talk to relay the offers that we have. We're gonna have at least one plea and maybe one or two others.
Okay, so
Mr.
you need a few moments to talk to them?
Yes, Your Honor, I'm waiting for the deputies to bring them down now.
Okay.
The rest of the calendar is just gonna be resets. So we could either take that up now or when you're ready or break to wait.
Yeah. I'm going to do the resets on the 11 a.m. calendar in a breakout room. But before I join you, I had a couple of people asking a question. Miss Greenhouse, please hold. We may be taking some pleas at the 11 a.m. calendar. All right, this person who's got his hand up, 1+ CPH 2515. Please unmute and start your video.
He was going to review.
Hey, Judge. Good morning. How you doing? Hey, how you doing, Judge? I couldn't hear because I had to go to the bathroom. I just missed what was said about Mark Williams.
TMI.
I'm sick. I can't talk loud. I said,
Who are you calling about?
Man, Mark Williams. I'm on the case. I was trying to see I couldn't hear. I just went to the restroom and I came in at the last minute. I've been on and off.
Mark Williams.
Yes, ma'am.
His attorney has entered a not guilty plea, and his cases are going to be continued for a jail jury trial calendar.
Jail jury trial calendar. Okay.
One of his cases may possibly be transferred to the Superior Court as a felony matter.
Okay. Yes, ma'am. Thank you.
You're free to go. Thank you.
Oh, shit.
All right. Miss Champion, if you can lower that hand. Okay. Yes, sir. On OnePlus, whatever that phone is. What's your name?
My name is Reggie Matthews. Good morning, Judge. How you doing?
Doing well, thank you. Good morning. And who are you calling about?
I'm calling about my Rodriguez Matthews. I had called Fulton County Jail, and they stated that he was on the calendar.
Matthews. Okay, just give me a
Yes,
moment.
ma'am. Yes, ma'am.
Not
I
today.
believe that might be on the 11 o'clock calendar.
Okay.
Okay. All right. If that is the case, Your Honor, I believe that is my business before the court. May I be excused?
Yes, Mr. Scirocco, you are free to go. Have a good weekend. Thank you.
Thank you,
He's
Judge. You as well.
position, he's
Bye,
position
everyone.
11 on the,
Yeah, I see
11
him.
o'clock calendar.
Mhm.
Okay.
What's your name, sir?
Reggie Arnez Matthews.
Okay, let's
I'm
go ahead
here-
and change. Let's go ahead and change his screen name to Reggie Matthews. Mr. Matthews, you need to hold, and then we will let you know what's going on in the other Mr.
Rodriguez.
Matthews case. Yeah.
Rodriguez. That's my son,
Rodriguez.
ma'am.
Okay, we'll
Judge.
let you know, but we haven't addressed that case yet.
Okay, I was just letting someone know because I had went down to Fulton County and
Please hold. You can tell me later when I address the case, okay?
okay.
All right, thank you. Please mute your screen and switch your video off. And don't raise the hand. Okay, thank you. All right, courtroom 2. And then we have someone on Samsung. Who is that? All right, thank you, Ms. Smith-Man. I think we may have a couple of pleas, so please hang on, and then we will address them shortly. Okay, courtroom 2. All right. Mr. Bartel, do you want to go into a breakout now, or do you still want to talk to your clients?
Are they coming on are they on the way?
Your Honor, can I get a 3-minute break?
Yeah, that's why I'm going to just get an update. And Mr. Bartel, otherwise I'm taking a 10-minute recess.
Okay, Your Honor. That's fine. Maybe we can talk to people then. I think they're bringing the other folks in.
All
now.
right. We will defer on the breakout until you got a chance to speak with them. It is 11:46. We will resume at 11:56 or 11:57, according to my clock. Thank you. Miss Champion, could you pause the recording while we're on recess? Thank you.
Yes, ma'am.
Oh, that was. Miss Smith, man, as soon as Mr. Bartell is done with his please, he'll let you know, because I have no idea.
Okay, thank you, Your Honor.
If he's not there.
Okay. Courtroom 2, are we ready?
No, Judge. Paul Bartel still interviewing his client.
Okay, we'll check back at 12:05.
Your Honor, I think we're ready to proceed.
Okay, Miss Greenhouse is here. Excellent. I just want to make sure that is probation going to be required for any of the proposed plea offers?
That is correct, Your Honor.
Okay. Is JCS available?
They're on, Your Honor, but Miss Jory Mann and myself wanted to know who were taking pleas so we can have our sentence sheets. And she was
Okay.
trying to pull the history.
Yeah, I just want to make sure probation's on Zoom as well.
They're on Zoom, but you may want to call them out again.
Yes.
Mr. Bartel, who are the cases that we're addressing the plea?
It's number 7, Your Honor, Mr. Hernandez. Number 11, Mr. Matthews. Number 12, Mr. Morale. And Mr. Smith is number 15, Your Honor. I think we can do it in that order.
7, 11, 12, and 15. Okay.
Are they all negotiated, please?
Well, yes and no. Well, Mr. Morale, I think that's non-negotiated. We're just asking for a little extra time in lieu of no probation. And Mr. Smith isn't sure what he wants to do. So we told him we can give him a little time to think about it.
Okay. We'll take those up one at a time. Do all the pleas involve probation?
Well, if the court will go along with that request, Mr. Morale's plea will not. All the others do involve probation.
Okay, let's take Mr. Morale first then.
Mr. Morale, you can come.
Decide.
And Ms. Tucker, if you can chat me those or email me those, please. You could chat them.
Yes.
Thank you.
Okay. And just to let Ms. Tucker and Your Honor, the offer for Mr. Morale is basically probation. Thompson,
no. I'm looking for non-probation cases because probation hasn't responded. I took a recess until 12:05.
Well, Basically, Your Honor, the offer is time served, credit for time served, probation, and MHET, and stay away from MARTA. Mr. Morrell advises me he's from South Carolina, from Beaufort, South Carolina. He is aware of a place he can go there to get services. He has family in South Carolina, and he really doesn't want to stay in Georgia anymore.
I see. Okay.
He's very nice.
Any objection, Ms. Tucker?
No, if he's
All
gonna
right.
be out of our hands.
Time served.
All right, thank
So that's so that would be the non-probation case. All right. So Ms. Greenhouse, if we will proceed with this case first. This is position 12. No, not yet, Mr. Morrell. Yeah. I still need to ask you some questions, Mr. Morrell, but let's begin. This is position 12 on our 11 a.m. calendar, 26 CR 002-751H, Montario Lamont Morrell, Morrall, accused of criminal trespass from April 29th, 2026. Mr. Morrell, you have a right to remain silent. Anything you say about the facts of your case in open court, your statements can and will be used against you. You have a right to an attorney. If you cannot afford one, one will be appointed to represent you. May I place you under oath so that we can proceed with the plea hearing? Raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge? Ms. Tucker, what's the recommendation?
Yes, Judge, it'll be 12 months to serve 18 days, credit for time served 9 days, balance suspended with a stay away from MARTA.
Mr. Bartel? Mr. Bartel, does your client accept these terms?
Yes, he does, Your Honor.
And do you stipulate to the factual basis, venue, and ID?
We do so stipulate for the plea.
All right. The state's offer was 12 months to serve 18 days, credit for time served 9 days, balance suspended, stay away from water. Mr. Morrell, have you consumed any medicine or alcohol recently?
No, ma'am.
Have you understood what's going on in your case?
Yes, ma'am.
Are you satisfied with your attorney?
Yes, ma'am. Yes, ma'am. Yes.
If you decide to plead guilty, you will not get a chance to have a trial. You will not face a judge or a jury in the future for this case, nor you cannot confront your accusers. You will not be able to present your arguments in a court of law, and the prosecutor won't have to prove the charge beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to 1 count of criminal trespass at MARTA?
Guilty.
Your sentence is 12 months to serve 18 days, credit for time served 19 days, balance suspended. You'll be released within 24 hours, but you are not allowed on any of the MARTA trains, MARTA buses, and you cannot be seen in any of the MARTA stations. You are to avoid all MARTA property.
All right.
Yeah.
All right. If you return to South Carolina, then you won't get arrested in Georgia. Thank you.
Thank you, Judge.
All right. JCS, are you present? I just want to make sure that probation is here so that we can proceed with the pleas.
Your Honor, I don't know if this, I mean, you know that I do give them the paperwork. We give probation the paperwork.
I know.
You want me to give somebody a call there?
Yes, please, because I
Okay, give
don't
me
know what
1
else to
second.
do. If they're not there,
'Cause
or,
I give them the sentence sheets and all of that, so they pick
okay,
it up.
then let's proceed and then you can provide them with the paperwork.
Yes, ma'am.
Okay. Position number 7, we have State versus Daniel Hernandez Nava. Mr. Hernandez, along with Mr. Matthews and position number 15, Mr. Ricky Smith, they're all in the courtroom?
That's correct, Your Honor.
All right. Gentlemen, we are about to address each of your cases. I want you to remember the following rights. The first right is the right to remain silent. Anything that each of you say about the facts of your cases in this courtroom, your statements can and will be used against you. So please don't make any comments except respond to your attorney's or the judge's question. You have a right to an attorney. If you cannot afford one, one will be appointed to represent you. Just as a caution, if you make any statements without consulting with your attorney, those can be used against you in a court of law. Okay, Mr. Hernandez is charged with simple assault, family violence, criminal trespass, causing damage to property, terroristic threats and acts, and reckless conduct. May I place you under oath for the plea? Please raise your right hand, other right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am. Yes, ma'am.
Ms. Tucker, the plea offer for Mr. Hernandez?
Yes, Judge. On the simple assault family violence, it's going to be 12 months to serve 60 days, credit for time served 22 days, balance probated, to complete an MHET, complete the family violence intervention program, have no further contact with Elena Fink, and to stay away from her location at 1450 Raintree Drive in Roswell, Georgia. On the criminal trespass and damage, it's going to be 12 months to serve 60 days, credit for time served 22 days, balance probated, and 20 hours community service. On the terroristic threats, it's going to be 12 months to serve 60 days, credit for time served 22 days, balance probated with an additional 20 hours of community service. And then on the reckless conduct, 12 months to serve 60 days, credit for time served 22 days, balance probated, an additional 20 hours community service. So that'll add up to 60 hours total.
Mr. Bartel, does your client accept these terms, and do you stipulate to the factual basis, venue, and ID?
He does, Your Honor. That's our understanding of the offer. He does so stipulate, and I'll also let the court know that Mr. Hernandez does speak very good English. I did speak with him with an interpreter, but he was able to understand everything I said without an interpreter. We also talked about immigration consequences. He advised me that he was born here in Atlanta at Grady Hospital. So given that, he's lived in America all of his life, is a U.S. citizen, but we did talk about that. And asked the court to consider accepting the first 2 months or waiving the first 2 months of probation fees.
Mr. Hernandez, did you understand everything that your attorney just explained?
Yes, ma'am.
All right. So if you are a U.S. citizen, then the immigration consequences don't apply. Would that be correct?
Yes, ma'am.
Okay. Have you consumed any medicine or alcohol recently?
No, ma'am.
And have you understood what's going on in your case?
Yes, ma'am.
Are you satisfied with your attorney?
Yes, ma'am.
If you decide to plead guilty to these charges, you would have to give up your right to a trial. You will not face a judge or a jury in the future. You will not be able to confront your accusers, challenge the evidence brought against you in a court of law, and present your own defenses and arguments. The state won't have to carry its burden and prove the charges beyond a reasonable doubt. Are you prepared to give up all these rights?
Yes, ma'am.
How do you plead to one count of simple assault, family violence, criminal trespass causing damage to property, terroristic threats and acts, and reckless conduct?
Guilty, Your Honor.
On count 1, your sentence is going to be 12 months to serve 60 days, credit for time served 22 days, balance probated. Counts 2, 3, and 4 will all follow the same 12 months to serve 60 days, credit for time served 22 days, balance probated. For count 1, you would have to complete a MH evaluation and submit yourself to all treatment and counseling that's required. And you will need to do this within 30 days of being released. For count 2, there's more. You would need to enroll in a domestic violence intervention program, and you must do this within 60 days of being released, and you must complete all 24 weeks of classes without missing or skipping any of them, and pay for the classes out of your own pocket. At all times, you're to have no contact with Elena Fink, and you're to stay away from the Raintree location in Roswell, Georgia. For count 2, criminal trespass causing damage to property, you will have to do an additional 20 hours of community service. Count 3, terroristic threat, another 20 hours of community service. And count 4, reckless conduct, another 20 hours of community service. That's a total of 60 hours of voluntary community service that you must do at any nonprofit agency, and it cannot be a church and it cannot be a school. You will do your community service at a minimum rate of 10 hours per month. I will waive your probation fees for the first 2 months as long as you enroll in your domestic violence intervention program within 60 days of being released. If you do not, the 2 months fee waiver will be reinstated. Any questions?
No, ma'am.
All right, that concludes this case. Thank you.
Thank you, Judge.
Good looks. Thank you. Yes, sir.
The next position is going to be Mr. Matthews, position 11. This is State versus Rodriguez Matthews, charged with simple battery from April 28th, 2026, and simple assault, same incident date, case number 26 CR 2752E. Mr. Matthews, you've been advised of your right to remain silent. Your attorney is Mr. Bartell. What's the recommendation, Ms. Tucker?
Yes, Judge. On the simple battery, it's going to be 12 months to serve 30 days, credit for time served 9 days, balance probated, to complete the mental health evaluation and any recommended treatment, complete 12-week anger management, 40 hours of community service, to have no further contact with Brittany Butler, and to stay away from Grady, unless seeking emergency medical attention. On that simple assault, that'll merge into the simple battery.
Mr. Bartell, does your client accept these terms, and do you stipulate to the factual basis, venue, and ID?
Yes, Your Honor. That's our understanding of the offer. We do so stipulate for the purposes of the plea. He wanted to clarify about Grady. We would just ask that be stay away from Grady unless seeking emergency treatment or he has an appointment there.
All right, and he understands that he'll have about 3 more days to serve at the jail.
Right, that's correct. I got 6 more days. Basically,
Oh, is it 6? Okay, I may have.
2 for 1 on 30 days, and he served 9 days. And we would the court to consider waiving 2 months of probation fees so he can get started with the community service and classes.
Okay. Mr. Matthews, his relative, did he want to address the court? Reggie Matthews? Reggie Matthews, if you want to address the court, you need to unmute and start your video.
You're muted, sir.
Can y'all hear me now?
Do you want to say something?
Yes, ma'am. I was just letting the courts know that I'm his father, and I was just coming down now, just letting you guys know that the solicitor said, Ms. Tucker said that I got a appointment. We waiting on his psych evaluation appointment to come up so he can get a psych evaluation. I have his medicine right here with me that I was trying to bring down now to let someone know that I do got his medicine with me now, and he's been living with me for the last year now, and I just wanted to update my address for him so that anything that comes for him, it need to come to me because I'm his payee now, because I had got all his information and his mom turned everything over to me, and I got everything set up where we was waiting on his SSI to get started, and he had got in trouble, and so that I can get the thing set up where he can pay off his fines and things of that nature.
Mr. Reggie Matthews?
Yes, ma'am.
I appreciate that information, but most of it is not really going to be applicable. He is pleading guilty to the charges at the present time if this hearing moves forward. And if he pleads guilty, he'll be released from the Fulton County Jail within 6 days. And he'll need to report to probation, where he'll need to complete certain requirements, certain classes, certain programs, do community service, pay probation fees. He also is required to stay away from Grady Hospital unless he's got a verifiable appointment or he's seeking emergency treatment.
You
So
understand?
once he is released, will he be living with you?
Yes, ma'am. That's why I was trying to let someone know that my address need to be updated in the system for anything that goes on.
So you can come down to the clerk's office, or
Yes,
you can
ma'am.
provide your address in the chat.
Yes, ma'am.
All right.
Okay, thank you so much, Your Honor. I just wanted to let someone know that he had someone on the outside that was coming down there on his behalf.
As long as he lives with you, that's fine with me. All right, please
Yes,
mute
ma'am.
your screen.
Thank you, Judge.
And Mr. Bartel, you did stipulate, right?
I did, yes. Your
Thank
Honor.
you. Mr. Rodriguez Matthews, have you consumed any medicine or alcohol recently?
No, Your
I can't hear you. You need to sit up straight and speak into the mic.
no, Your Honor.
Are you aware of what's going on in your case?
I'm aware of what's going on.
And are you satisfied with your attorney?
Yes,
I'm sorry, what was that response?
he wasn't sure if I was doing probation or anything, but I was satisfied.
Are you happy with the legal services you received?
Yes.
If you decide to plead guilty to the charge of simple battery, you would have to give up your right to a trial. You will not go back to a courtroom to face a judge or a jury. You will not get a chance to confront your accuser. You will not get a chance to challenge the evidence brought against you. And the prosecution won't have to prove the charge against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes.
How do you plead to one count of simple battery?
Yes.
How do you plead to one count of simple battery?
Guilty.
Your sentence is going to be 12 months to serve 30 days, credit for time served 9 days. You have a few more days to serve at the Fulton County Jail. Once you have completed that extra time, you will be released and you must report to the Fulton County Probation within 48 hours of being released. If you do not report to probation, they will have you arrested again. While you're on probation, you will complete a MH evaluation and you will submit to all treatment and counseling. If you're currently seeing an MH doctor or a therapist, you shall continue with that treatment until you are discharged. You will also complete 12 anger management classes, and you must enroll in that program within 60 days of being released. I will waive your probation fees for 2 months as long as you enroll in the anger management classes within 60 days. If you do not enroll in the anger management classes within that time, your probation fees will be reinstated into your account. You are also to do 40 hours of community service. This is 40 hours of service that you will do at any nonprofit agency. It cannot be a church and it cannot be a school. And you must do your community service at a minimum rate of 5 hours per month. You are to have no contact with Brittany Butler, and you're to stay away from Grady Hospital and Grady Medical Facilities unless you have a verifiable appointment with a healthcare provider or if you're seeking emergency treatment. Thank you.
Thank you, Judge.
Next, we have position number 15, was it?
Yes, Your Honor, Mr. Smith. Okay. Yes, Your Honor. This is Mr. Smith. He's number 15. We have an offer from the state. I've relayed it to him what the offer is. He is asking that the court just give him time served with the probation conditions. Is that correct? He is wanting the court to give him time served with the probation conditions rather than the additional time to serve. He indicates that he has family members that he needs to help take care of, but he indicated he wanted to address the court regarding that.
Okay. This is Ricky Smith. Mr. Smith is accused of battery, theft by shoplifting, and theft by taking from April 29th, 2026. Case number 26CR 002775A. Mr. Smith, you have a right to remain silent. Anything you choose to say to us in open court, your statements can and will be used against you in the treatment of your case. You have a right to an attorney. If you cannot, since one is appointed to represent you, I highly recommend that you let your attorney speak for you, especially if anything you say could be used against you. But if you choose to waive your right to remain silent and you want to address the court directly, that is a decision that you can make entirely up to, it'll be entirely up to you. All right, but you must waive your right to remain silent, and you must do that knowingly and voluntarily. And I've already told you the consequences if you choose to waive your right to remain silent, and if you want to address the court openly during this proceedings. I understand that the plea offer is 12 months to serve 90 days with credit for time served 8 days. So how many more days would he need to serve at the Fulton County Jail?
I've got 7 days, Your Honor. 90 days, 2 for 1 credit is 45, minus 8.
So it'll be 38 days?
37.
37 days, okay. Is that correct, Ms. Tucker?
Yes, Judge.
All
And
right.
that's based on both the history and the facts. He's got 62 total cycles. As recently, he just pled guilty for a battery, a simple battery on 4/3/2026 with Judge Taylor. And then he also has a guilty conviction out of 2025 on a felony case, obstruction of felony level obstruction, felony level terroristic threats, and aggravated battery against a law enforcement. Those are convictions. He's got a criminal trespass conviction from November 2025, a trespass conviction from May 5th, 2025, conviction simple assault and obstruction from January 22, again, obstruction and shoplifting, 2021, public indecency, 2020, more shoplifting. He's just got a very lengthy criminal history, as well as the facts in this case. He stole a candy bar from a gas station. When he was confronted by the store manager, he punched him in the face. Then he fled and ran down to the Best American Hotel and took the cell phone of a second victim. So we have 2 victims here, as well as all that history. The battery did leave visible injury. So we think 90 days is very reasonable considering, they're 2 for 1. He's only got to serve 45. So that's the state's offer.
Okay, I'm just going to take a brief pause here. Ms. Thomas, thank you from probation. Thank you. And we've already done a couple of pleas. I don't know if you were part of that. but Chanel Young will definitely transmit all the plea paperwork to you. And it is for positions 7, 11, wait a minute, 7, 11, 12, and 15 from our 11 a.m. calendar. Okay, so we'll definitely have you caught up with all the paperwork. Mr. Jacoby Hudson, please unmute and start your video. Good morning.
Hey,
sir.
Judge.
Hello.
I'm here in
Hello.
Fuchs County. Thank you.
All right. Unfortunately, we've already done with the SAP calendar, and we've advised your client, Mr. Was it? Oh, yeah,
Jacobius Hamilton.
Hamilton, that we're going to reset him to May 12th at 9 a.m.
Okay.
All right.
That's
At
fine,
which
Judge.
time you can let us know, or do you know if your client is taking a plea or is he?
Yes, he's taking a plea.
All right. Then we will address that on Tuesday.
Is it gonna be with you, Judge?
No, it's going to be with Judge Morrow.
Judge Morrow? Okay, that's fine. Thank you. Same
right.
Zoom link. Same Zoom link, Judge. For the SAP calendar?
I don't know. I don't know what's the Zoom link for Tuesday. Sorry.
All right, I'll reach out to Ms. Young.
It's the
Okay.
same
All right.
thing.
It's the same.
Thank
Ms.
you.
Young says it's the same. Thank you.
All right, thank y'all. All right,
Okay.
bye-bye.
All right.
And Your Honor, just to clarify, with probation on number 12, that would be just a time served.
Yes. Position 12 is time served. I was just advising Ms. Thomas, who's joined us she's with probation. Okay. All right. So getting back to Ricky Smith. So, Mr. Smith, you have heard as Mr. Scirocco puts it, a robust criminal history record. You've heard the allegations of violence that's been asserted. And if you choose to discuss those allegations, your statements can be used by the prosecution in the trial of your case. So do you want to say something about your case now, or would you like your attorney to speak on your behalf?
I'd like to speak on my behalf. What is it?
Mute your screen, Mr. Bartel. Go ahead.
Yes, Your Honor. Based on what Mr. Smith is telling me and some things he has told me in the past, I think we need to enter a not guilty plea and further notice.
I'm trying to get my time. I ain't trying to do that, man. That's not even what happened, I'm tired of folks keep trying to
telling me this is not what happened, Judge. So
somebody stole somebody at the store. This man pushed up on me, trying to push me out the store, put hands on me. Folks keep trying to charge me for defending myself. I can't plead not guilty, not hit the man anyway. I'm not saying I ain't hit the man, but it was a reason. Folks keep trying to say I did it and the third. That ain't even what the fuck happened. Excuse my language. I got a mother out there and he got no job. Lady got 2 kids. I would have been home. These folks out here playing with the bus route, seeing when I got out the last time on 14. Last time. When you ever seen four buses leave? Hey, hold on, bro. When have you ever seen 4 buses go the same route? I'm supposed to be home. These folks gave me a direct order to go home. These folks signed off supervision in the probation to go to the program. I go to the program. These folks, I gotta go through a whole other protocol. Ain't that? I'm tired of this, y'all. But it's always me. I always got time for that, y'all. Crazy, but my folks out there suffering, bro. I ain't trying to say, but give me a pass or no time for these duty sentence, something. You better than 15 or something. Like, damn. I ain't saying I ain't hitting that. This is more different. It's for sure a reason behind it. And I ain't got no phone on me. He supposed to pull up on me for no reason, talking about what a crackhead or the crack smoke do. He supposed to go out what a crack smoke do. That was a whole.
So you are saying that you allegedly struck this person because you acted in self-defense?
Yeah, man, he pushed. He always.
I'm asking you, yes or no?
No.
Okay. So you are asserting a self-defense, which definitely merits a trial.
I don't want no trial. I want to read the deal. I don't want no 45 days, bro. That's not powerful. I'm asking you for a favor. I don't want no guilty. I don't want no 90 days.
Sir, if you're telling me that you acted in self-defense, then you clearly are not guilty of this offense, and you have a right to a trial.
Man, that makes sense. How you not guilty when you still hit the man? That still makes sense.
If you are telling me that you hit him and you did not act in self-defense, then you will have to stay in jail for another 37 days.
Man, shout if you shoot somebody instead of me, you still gonna get time. You just gonna get
I'm
reduced.
still going to give you time, yes, if you are going to plead guilty to the offense.
You catch a murder charge, you shoot somebody instead of feet, they don't reduce your charge.
I am going to give you time. Would you like to plead not guilty, or would you like to proceed with the plea?
I will see you. Bullshit.
I am sorry, what did you just say?
Yeah.
Sit up straight and speak clearly. What did you just say?
Proceed. Yeah.
Your Honor, I think given what is on the table and what the court would be inclined to go along with, maybe a reset would be in order.
Granted.
Maybe a 1-week reset to
2 weeks.
2 weeks. Okay.
I don't reset it soon. You dead. Fuck you, bro.
Would that be?
The case is reset for 4 weeks, and this case is reset for 5 weeks.
Would
Okay,
that?
we can mute the screen. This Miss Young, this case is reset 30 days. Oh, Mr. Bartel, were you going to enter a not guilty plea? Oh, let the courtroom calm down.
Yeah, I'm waiting till the door closes, Your Honor. Yeah, would that be a reset to the 11 a.m. calendar or SAP?
You tell me.
Well, I think I would need to deal with it either way. So,
okay.
How about 11 a.m.
calendar? 30-day reset to 11 a.m. calendar.
Okay.
And Ms. Tucker, I'm rejecting this offer. In 30 days, if y'all want to come up with another offer, that's fine with me.
Okay.
Thank you.
All right, thank you, Judge. Sorry about that.
No, that's okay. Reset 30 days. And that concludes our pleas for this calendar, correct?
That is correct, Your Honor.
All right. Thank you, Ms. Greenhouse. You are
Okay,
free to go.
thank you. Thank
All
you.
right.
Good to see you.
And Ms. Young, we can stop the live stream and the recording, please.
Yes.
Thank you.
So we're gonna put him on for May 7th. No, today is May 7th. I'm sorry.